Um, I do have the chart sheet with me, Advocate Caesar, if you want to go on record. Please. Yes. Are you submitting the SAP 69 form? Just for the record, so that we know where to find, the matter is now proceeding in another venue as where we started this morning, being the High Court at East London. Advocate Odes, I see you are rising. Is it in a to proceed, or may I just address an aspect before we proceed? Sorry? Please proceed. All right, I want to make it absolutely clear that since I've been moved from my court and my chambers to this court, I cannot carry all the documents that may be needed. I do not know what the defense intends leading or asking me to rule on, or so I cannot entertain any complaints if I should adjourn to fetch any document or any anything that I may need, because I am not in my own chambers. And I want to make that very clear. Understood, Advocate Caesar? Okay. There's no other way. I cannot anticipate and bring everything. So I just want to make that clear. Advocate Otis, I'm sorry for that, but it's a distance and it's impossible. I do not know what you may need from me. And if anything, I will maybe then have to collect it in chambers. Thank you so much. Then if you are ready, by all means, we may proceed. Thank you so much. Just to remind the media that earlier we had made an order, or this court had ordered, and even when she enters, that there are to be no visual images of the witness, only oral. So please, even on her entering, no visual. Thank you. The witness, just for your own benefit, as you were not present when we discussed the issue, you may just be informed that it has been brought to the court's attention that there will be no media footage or visual footage. It will be a mere oral recording. May you please state your full names and surname for the record, please? Do you have any objection in taking the prescribed oath? Do you then swear that the evidence you are about to give will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you. Are you comfortable there? If there's documents, okay. If you are, I would rather you be comfortable. Is there a possibility of us just moving the microphones a bit so that she has space for her documents, please? Okay. Thank you, Advocate Otis. Much appreciated. Thank you. Thank you.
Can you tell the court briefly what the consultation is?
I do have a PhD in social work.
You need to start just the message so the EA degree in social work.
A master's degree in social work. And a LLB.
So the EA degree in social work, the master's degree in social work, and the LLB.
That is correct, Your Worship.
What is your current occupation?
I am currently a social worker and working part-time in private practice.
I'm sorry, ma'am. There's a noise from this side, people speaking, so and the audio is not very good in this court.
What's the
Yes.
You're a social worker, you currently in private practice.
That is correct, Your Worship.
You can raise your voice, please. In that capacity, you have compiled a report for the security director.
That is correct, Your Worship.
Can you please talk slowly and loud as you possibly can take us through the report related to the security of the issue of safety?
Just regarding one aspect, I'm sorry to interrupt. Is there going to be any need for interpretation of the report? Is there anyone that will request that? The state?
No, Your Worship.
Then thank you. We proceed. Yes, ma'am.
Slowly and as loud as possible.
Identify the witness. Name is Julius Malema. ID number 810.
That's fine. Just you don't have to read the identity number. I'll leave that up to Advocate Otis. I was just thinking that there's no need to read out an identity. You want the whole number read out? Yeah. No, as long as you're comfortable with that, I just didn't want it to go. Then sorry, you may proceed.
I will proceed. Name is Julius Malema. Marriage. Separated in English. Age 44 years. Marital status married. Children, 3 children, age 19, 9, and 7 years. And the address is in Sandra and Sandra. Introduction. Mr. Julius Malema here often referred to as the accused faced the following charges. accused discharged firearm illegally in the Easter anniversary celebrations. Section 121, which is the law of the Firearms Control Act 2000, outlines the statutory penalties for contraventions of the Act. There is no indication that the charges should also be read with Section 51 and Schedule 2 of the Criminal Law Amendment Act 105 of 1997, which prescribes minimum sentences for certain offences, including those related to the possession of an automatic and semi-automatic firearm. The defense requested the undersigned social worker to compile a pre-sentence report. The primary objective of the report is to provide the court with relevant information concerning the accused and his personal circumstances, thereby bringing to the determination of the appropriate individualized sentence.
Ms. Thompson, sorry to stop you. Can you please attempt to just raise your voice? You have to shout. It's difficult for the people in the back. You don't hear what you're back. I know it's a bit good, and I apologize.
Really talking about
Those microphones don't get your voice. They don't have to.
so if I place perhaps
You don't have to face the. You are more than comfortable if you want to turn.
As long as you raise your voice.
the defense requested the undersigned social worker to provide a pre-sentence report. The primary objective of this report is to provide the court with relevant information concerning the accused and his personal circumstances, thereby informing the determination of the appropriate individualized sentence. The information presented is limited to circumstances pertinent to the matter, in adherence to the principle of confidentiality and the avoidance of unnecessary solicitation of information. The investigation conducted for the purposes of this report includes the following components: individual evidence of the accused, lateral information obtained from individual witness rights to persons and persons, relevant research including information regarding the offences, sentencing options and aspects related to the accused functioning, supporting documents as reference indicators, footnotes and all resource lists, a visit to the Macacanemistic kitchen, located at Tikata and Dictionary and the Table Club, conducted during the final interview of the king's residence in Chokwan. Additionally, an Enneagram personality type assessment was undertaken. This assessment was primarily suited to coaching purposes, providing insight into core motivational drivers rather than observable behaviors. The information regarding the accused personality is intended to offer context to his conduct and potential related expectations, and should not be used to consider services and or assumptions. Throughout the process, the accused was open and forthcoming, willingly shared information and often incorporating educational elements into discussions, such as the significance of his second name and the rationale behind the focus of his last statements. The judgment script as a source of facts involved in the matter. Detailed information concerning the effects of the element outlined in the form prior, as well as other relevant considerations were introduced in the parliamentary law. Recommendations and opinions are based on information available at the time of consultation. The undersigned social worker reserves the right to amend these recommendations and opinions should additional information become available. Personal circumstances, family background. The accused was born on 3 March 1981 to a single mother. His mother suffered the loss of 2 children, an older sister to the accused who passed away before the birth, and a younger sister who did not survive beyond the age of 2, resulting in him being raised as an only child. His mother, who was one of 9 siblings, resided with his sister, his siblings, and their respective children in his grandmother's house, located in the Massachusetts section of the Shale Township on the outskirts of California. At the time of his birth, the extended family, each sibling having at least 3 children, shared a modest 4-room home comprising 2 bedrooms, a lounge, and a kitchen. The kitchen was routinely converted into an additional sleeping area. At night, the accommodation was running. The accused largely dining in noisy kitchen, considerable number of occupants in the confined space, which led him to daily drivers and received solitude when confronted family to marry at 21. The household was in significant financial hardship, subsisting on his grandmother's social loan, his mother's earnings from years work, and the occasional income from his honest and good job. The accused and his cousins were raised within this environment, learning from an early age to share the limited resources available to them. Despite the challenging socio-economic circumstances of his family, both his mother and grandmother consistently modeled a strong commitment to serving others, which profoundly shaped his values and approach to life. His mother, a dedicated Christian, was actively involved in community service through the church, while his grandmother contributed to the well-being of those around her in her role as a traditional leader. These examples established a foundation of communal responsibility that continued to influence his actions and decisions. The accused grew up in the absence of a father figure, as neither his mother nor his grandmother ever disclosed his father's identity to him. To this day, he remains unaware of who his father is. He left his childhood in 2001 after being elected president of Qatar and returned to Morocco in 2003. Upon his return, he established his own residence, but maintained those close ties with his family, particularly his mother and grandmother. By that time, his mother's siblings had relocated to Orpington houses, while his mother, who suffered from epilepsy, continued to reside with his grandmother. Following the passing of his mother in October 2006, the accused assumed ongoing responsibility for the care of his grandmother. Although he shared strong bonds with both maternal figures, his relationship with his grandmother was especially close. The death in May 2019 marked a significant loss, yet he continued to honor and maintain a deep ancestral and spiritual connection with her. From an early age, the accused was instilled in the Grant's family, consistently spending significant occasions such as Christmas and Easter with regular people importance. Upon earning his own income, he undertook financial responsibility for his extended family by paying his cousins' school and tertiary education fees and continues to support their entrepreneurial endeavors. The accused considered himself a mentor and elder brother to his cousins and son to his aunts. According to his wife, the accused devotion to his mother and firstborn sons, together with his strong family orientation, were qualities that attracted her. He provides for his family, approaches his responsibilities diligently, and has maintained commitment to his community even after attaining success. All collateral sources consistently highlighted his deep family bonds and his active community involvement. The accused's eldest son was born in 2006, and though not married to the child's mother, the accused remained involved in his son's life from birth and continued this involvement following their separation. His son would visit during school holidays, and since January 2018, has resided permanently with the accused and his family. He is frequently involved at the University of Tehran, pursuing a Bachelor of Arts degree in philosophy, international relations, and politics with the intention to further his studies in law. The accused married his wife in 27 December 2014, and together they have two sons aged 9 and 7. Both children attend primary school but are enrolled at different schools. This decision, taken jointly by the accused and his wife, was based on the careful consideration of the children's personality, needs, and their interests, with the aim of allowing each child to develop socially and ultimately to fulfill their. The accused wife is a dedicated stay-at-home mother, making it only the financial provider of their household. In recognition of the value of her role, the issue consists to manage their house, expressing his belief that stay-at-home mothers deserve to be compensated for their contribution. Particularly, George worked career as a qualified financial advisor in the corporate and investment banking sector to focus on raising their children. Nevertheless, that continued to study, both remained professionally engaged and to prepare for a eventual return to her professional career. Having grown up without a father figure and in a household with her not married, the accused was committed to provide his The accused commenced his formal education at an fairly lower primary school in Seychelles, which is conveniently located in the grandmother's house. Conveniently located, sorry, apologies, where his grandmother's residence. During school break, he was sustained unbelievably to eat before he went to school. He later transferred to the Florida Ohio Primary School situated approximately 35 kilometers from his home, which made it exactly proximity to the grade. He completed his secondary education in elementary at the Main Secondary School in Seychelles, which was again within walking distance from his grandmother's house. In 2020, he attended school in Ghana and University through the University of South Africa. The following year, he enrolled in the Bachelor of Arts degree in Communications and African Languages, graduating in March 2016. He further holds a BA Honours degree in Philosophy and commenced a short Master's degree in Politics at the University of Witwatersrand, with a particular focus on decolonization and the removal of colonial symbols. While he has completed a coursework, he is yet to finalize the required legal protection. The accused political involvement began as early as 1990. At the age of 9, he joined the Magistrates, also known as the Young Pioneers or the Pale Raiders. Established in 1955 as the structure of the African National Congress, the Magistrates aims to provide political training and development for young people aged 7 to 17. The program emphasizes development of powerful skills, confidence, radicalism, and virtually, incorporating elements of basic military training, poetry, and public speaking. The core message is serving participants at the time was to promise a better life from the defeat of the apartheid government. After school hours, the accused would commute between East Township and other townships for Matsukatela activities, often leaving home on the completed of opinion self-practice. During his high school years, the accused became involved in the Congress of South African Students, COSA, an ANC-affiliated organization which increased education and advocated for improvements such as the abolition of corporal punishment, increased access to libraries, and the reduction of high school fees. By the age of 16, he was elected as the regional chair of COSA, Business Planning Corporate, and was elected provincial chairperson in 1997. Upon being appointed national chairperson of COSA in 2001, the accused relocated to Johannesburg. He recounted the challenges of this period, noting that he was young, without a steady income, and needed to secure both accommodation and community housing. Once he began earning his hours by giving financial support unto those depending on him. The accused's first remunerated role was the provincial secretary of the ANC in a total and elected position. Notably, prior to this, he served as bronze chairperson of the ANC chair in 1995, just before his 14th birthday. He was elected president of the ANC in April 2008 and served until his expulsion in April 2012. Subsequently, on 27 July 2013, he founded the Economic Freedom Fighters, EFF. In December 2014, at the EFF's inaugural elective conference known as the National People's Assembly, the accused was elected as president and commander-in-chief, positions he continues to hold. In addition to his leadership roles within the EFF, the accused has served as member of Parliament in the National Assembly since 2014. His parliamentary service includes participation in several committees. He is currently a member of the Joint Committee on Ethics and Members' Interests, the Joint Constitutional Review Committee, the Ad hoc Committee to investigate allegations made by the Kenyan General Plankton Finance, and he acts as a representative of the National Assembly on the Judicial Service Commission. In addition to the noteworthy input of his mother, and particularly his grandmother, the accused identified the late military leader Sisulu Baba and Winnie Mandela as key mentors and influential figures throughout his life. Based on the published 2018 relaxation in activities such as game drive, listening to music, and DJing. He also enjoys playing soccer with his children. As a private supporter, he enjoys attending big matches with friends, colleagues, and his children. He accused believes in God, although he doesn't regularly attend church services except on special occasions. His wife maintains a strong faith. In honor of his mother, who was a long-standing member of the Christian Baptist Church, he funded the construction of the modern church building, which was officially inaugurated in October 2009. Noting conduct, he refused to widely recognized as a revolutionary, someone who gives a voice to the voiceless, upholds a responsibility and respect of the advocating for the press. This is consistent with his personality type, which is characterized by keen sense of justice and regards to effects of change. He is willing to be confrontational when necessary, and then retract to protect the public using his own interests and the interests of those he protects. In his pursuit of influence, he maintains high standards for himself and those around him, often described as a perfectionist who is focused and committed to ensuring tasks of completed activity and within set periods. He values order and discipline, expressing a clear aversion to laziness, dishonesty, and being caught off guard. He regularly provides positive feedback when warranted, but does not hesitate to address unacceptable behavior. Importantly, once an issue has been resolved, he does not hold grudges. The accused personality provides further reflects a person's maintaining control of the situations and a willingness to act openly for misunderstood. He is motivated by a commitment to do what he believes is right, which is a pronounced desire for justice and the protection of others. The probe of further highlights his qualities as a natural leader. In situations of conflict, the accused has shown capability to criticize personal feelings and focus on resolving the issue at hand. He approaches such engagements robustly, ensuring discussion remains issue-focused rather than personal. Nevertheless, he is also capable of strong emotional responses to conflict, typically manifesting as irritation, frustration, resentment, or self-righteousness, particularly when confronted with perceived injustice, disrespect, or wrongdoing. He regularly expresses disagreement with instances that he perceives as an abuse of authority by persons in high office. Some of these traits were evident during some of his responses in cross-examination and accumulation of some of his comments in relation to his guilty verdict. Rather than adhering strictly to the status quo, the accused position himself as an initiative, the intent changing the political, economic, and social systems that are proven in the country and internationally. He is comfortable in pursuing alternative approaches, confident in the justification of his action. Consequently, the accused often attracts controversy due to his public statements and the seeming of historic songs. The collateral sources consistently describe the accused as a community-oriented leader who is deeply invested in the well-being of those who he defends. While the accused himself shares certain details regarding his community involvement, most of this information was obtained from collateral sources. Where the accused has not personally derived initiatives, projects are generally implemented through the organizational structure. The accused leverages his influence to mobilize key stakeholders within the community to respond to local needs, often facilitating in-kind contributions to the overall project. This approach is intentionally adopted to avoid any perception of financial impropriety. The following was shared with and co-authored by the undersigned social worker. During the relatively secure community, the method of cleanliness and emphasis on maintaining the dignity of residents are attributed to the accused priorities and involvement. In the Jubilee informal settlement, the community benefited from an water supply project funded by local contributions, including the setting of boreholes to address the inconsistent municipal water provision. The EFF, under the guidance of the accused, supported the community both by supplying water at critical times and by participating in the water initiative, which originated as a grassroots project. Additionally, in May 2023, Furthermore, a water tank installed on the premises to ensure wider community access to water during periods of municipal supply interruption. And I just want to focus on that.
All of us. Yeah.
Thank you. Each December is organized as an annual event and stipulates for school, hosting the Magistrates venues such as the University Hotel, where they are provided with motivational speaker, meals, refreshments, and gifts from each attendee. This initiative is designed to remove students from their usual township surroundings. Although this is a personal initiative, it gives advocacy, sponsorship, and shared support. He has expressed that his intention is to restore the benefits during community service with children, thereby inspiring and vision to exposure to new environment.
And don't you step on the forward, I think it's difficult to get population with their education.
I'll try to raise it a bit. In reaching out to the elders of the Christian community, it appears to ban by purchasing blankets and slippers for the elderly. Later expanded his efforts to the food courses in the EFF. During door-to-door visit and election period, we observed that many elderly residents lacked proper beds, which led to the launch of an initiative to provide beds, ensuring that no elderly person in these areas uses the floor, a point of personal pride for the accused. Through the EFF sponsored private training program, several community members have qualified as pilots, including the first female pilot from the sheriff, who achieved this milestone in 2023. On his 44th birthday, the accused donated 200,000 to the South Child Welfare Society. In November 2025, honoring the previous commitment, the accused handed over the disability-friendly house to a wheelchair-bound member of the shared community. Constructed by the EFF, this residence provides dignified and suitable accommodation to an individual that previously been living in inhumane conditions. Remorse, the accused entered a plea of not guilty to all the charges and following his conviction, continues to assert his innocence, stating that only a toy firearm was used when discharging his celebrating trust. He has publicly declared his intention to appeal the verdict. Although the accused regards his conviction as wrong, he regrets the incident and the consequent results that people may perceive as encouragement to handle firearms purposes. This was not his intent. Criminal behavior and public offense, previous convictions, and cases pending. The accused has no previous convictions and or any cases pending cases against. Current offense. The offences in question were committed on 28 July 2018 during the military representative and military celebration. The accused was arrested on 23 October 2019 and made his initial court appearance on 27 November 2019. The trial commenced on 1 March 2022 and concluded with conviction on 1 October 2025. The aspects of this case are as follows. Investigations were initiated after a review of the 15 lunch expired military celebration in the environment. On 30 July 2018, a spare cartridge was discovered to be posted in Hayden's room. The South African Police Service member responsible for overseeing the EFF celebration reported receiving no information concerning the discharge or simulation of firearms at the event. The accused was involved, was identified as the individual who was discharged at .223 November rifle. He possessed the rifle solely for the duration of firing the shot, after which it was handed over to another individual. It appears that the accused received the rifle ready to shoot from someone authorized to possess and handle it, most likely from Tactical Security Services, who provided security services at the celebration event. However, no individual was convicted of supply or controlling the firearm previously, and the rifle that was shown in court was returned to Tactical Security Services before judgment was delivered in this trial. Following the event, there were no reported injuries or damages to property or equipment used as used at the venue was inspected, and no damage was detected. Seriousness of the offences. In assessing the seriousness of the offences, it is necessary to evaluate both the level of actual and potential harm caused by the act in question, as well as the degree of culpability attributed to the offender. The Firearms Control Act 60 of 2000 describes sentences for such offences, including the option of a fine or imprisonment for maximum period ranging from 5 years to 15 years. For a first-time offender, convicted of possession of an automatic or semi-automatic firearm, the Criminal Law Amendment Act 105 of 1997 stipulates the minimum sentence of 15 years. As noted by the Court in the page 13, the Court in its versus minority observed that the enactment of minimum sentence legislation for the illegal possession of automatic or semi-automatic firearms was a response to the frequent use of such weapons in the commission of violent crimes. A single objective of the Firearms Control Act 60 of 2000 is to curb the proliferation of illegally possessed firearms and to prevent crimes involving firearms by removing such weapons from circulation. This purpose significantly heightens the seriousness of firearm-related offences. However, in the present matter, the considerations mentioned above do not apply and certain mitigating circumstances are evident. The accused obtained a firearm from an individual not likely affiliated to tactical security services who was authorized to possess and manage a licensed firearm. He did so solely for the purpose of discharging celebrating shots at the event. There is no indication that the firearm was acquired illegally for a prolonged period or with any intent to facilitate further criminal activity. It appears that the firearm was returned to its lawful custodian promptly thereafter. The accused's possession of the firearm and a single round of ammunition was limited exclusively to the period during which the celebration shots were fired, which, while not precisely timed, is estimated to have lasted less than 1 minute. Additionally, the Firearms Control Act seeks to uphold the constitutional right to life and bodily integrity and to penalize the negligent and unlawful use of firearms. In this context, the following considerations are relevant. There is no evidence that the accused intended to cause harm. Nonetheless, the court found that he discharged the firearm in a public space without implementing the necessary precautions to ensure the safety of people and property. By neglecting to take such precautions, it has been said that the accused acted recklessly, thereby endangering the lives of celebrating members, bystanders, and residents of neighboring areas, and risking property damage. Such conduct could have resulted in loss of life. It has also been said that the careless and reckless discharge of firearms in a public setting conveys an inappropriate message about gun safety and responsible firearm use, particularly when a prominent leader exhibits such conduct. The actions of individuals in positions of influence are likely to be emulated by their supporters, thereby warranting a more severe assessment of their behavior. It has already been noted that the accused regrets the incident and the consequent perceptions it might have created. However, there was no evidence indicating any harm to a person or damage to any property. Planning. The firing of celebratory gunshots was deliberately planned as a distinctive element of the event, reflecting the established tradition of incorporating unique features into each celebration. For instance, during the 10th anniversary, the accused approached a section of the stage that elevated into the air while red and gold confetti was released from cannons. Available information does not suggest that the planning of this activity was undertaken with the intention to commit an offence, endanger lives, or cause damage to property. Interest of society. The interest of society is upheld by imposing a sentence that delivers the greatest benefit and minimises potential harm. In considering an appropriate sentence, it is important to consider society's economic stake in the cost of the criminal justice system, ensuring that any punitive measure is justified by the tangible advantages it provides. The objectives of punishment are rooted in the protection and advancement of societal interests, encompassing prevention, deterrence, rehabilitation, and retribution. Prevention. As noted by Blanche, the incapacitation of an offender becomes especially significant when the individual poses a danger to society and when imprisonment is the only means by which the public can be safeguarded. In this instance, prevention is not regarded as a primary objective. The accused is a first-time offender, did not actively intend to cause harm, and no person was injured nor property damaged because of the offence. Furthermore, despite the lapse of many years, no subsequent offences have been committed. Deterrence. There are two recognized forms of deterrence. General deterrence, which aims to dissuade members of the public from engaging in criminal conduct, and individual deterrence, which seeks to prevent the accused from reoffending. The accused's personality profile suggests that his actions are driven by a desire to behave correctly and ethically. He has emphasized his position as the leader of the fourth largest political party, highlighting the considerable influence he holds over young people. He recognizes that he cannot credibly encourage others to respect the law if he himself is found guilty of a criminal offence. This awareness is expected to exert a strong individual deterrent effect. Furthermore, having been tried and convicted is also humiliating to the accused, serving further as an individual deterrent. Justice Edwin Cameron, a retired judge and currently sitting judge of correctional services, wrote in an article dated 9 August 2021 that the most effective deterrent to crime is the certainty of consequences, certainty of investigation, detection, arrest, arraignment, prosecution, and ultimately punishment. This principle was also affirmed by the highest courts, as reflected in the case of S versus Makunyani, which stated that the greatest deterrent to crime is the likelihood that offenders will be apprehended, convicted, and punished. It is the certainty of punishment rather than the severity of the sentence that is likely to have the greatest deterrent impact. Rehabilitation. Rehabilitation seeks to assist the offender in becoming a law-abiding member of society. While the accused maintains his innocence, he acknowledges the inherent risks of discharging a firearm in a public setting and regrets that the perception could be created that it is acceptable to recklessly discharge a firearm. He is a first-time offender and has not committed any further offences over the past 7 years. These factors, together with the individual deterrents previously discussed, suggest that rehabilitation The question is asked whether we would not be better served by expanding our idea of what constitutes justice. And bench, for instance, is warranted. There is a danger of in line with these sentiments, qualitative research conducted concern, we need to manage the sentencing practices pertaining to the administration of semi-automatic firearms. This will examine sentences in the context of the Criminal Justice Act 105 and the Firearms Control Act of 2000. The findings highlighted several key aspects: the implementation of minimum sentencing legislation for the illegal possession of automatic or semi-automatic firearms is linked to the prevalence of such firearms in the use of prevention of violent crime. When considering the application of minimum sentences, the specific purpose granted under which the possession occurs, as well as the intended purposes of possession of the firearm, are critical in determining whether substantial and compelling circumstances exist to justify deviations from the minimum sentence. Courts are more inclined to impose the prescribed minimum sentence in instances where the accused is also found guilty of other serious offences such as murder and robbery. Considering the facts of this matter, it falls outside the above-mentioned considerations regarding a decision to impose a minimum sentence. Furthermore, in line with the Matonga matter, bearing in mind that no evidence was obtained which suggests that the accused was forewarned about the likelihood of the application of the minimum sentence, it is respectfully submitted that the minimum sentence is not applicable. Despite warnings in the press with regards to the dangers of celebratory gunfire, no case law on conviction or sentencing for discharging a firearm for celebratory purposes could be found, indicating that charges are not generally instituted in this regard. The accused may be the first person charged with discharging a firearm for celebratory purposes. Annexure 2 of this report reference judicial decisions concerning the discharge of a firearm in public or incidents of reckless endangerment of persons or property. It's outlined heightening the risk of harm to individuals and property, the court found that a wholly suspended term of imprisonment was justified. Imprisonment, whilst the state's view on an appropriate sentence is uncertain, it is necessary to address relevant information relating to imprisonment. Imprisonment is widely recognized as the harshest form of punishment, generally justified by the objectives of retribution and deterrence. According to Cameron et al., except for in the most extreme cases, imprisonment remains a terrible thing. It has profound and far-reaching consequences for families, which extend across personal, social, financial, emotional, psychological, and physical domains. Since the family is often considered the foundation of society, any harm inflicted on it may worsen societal problems and contribute to elevated crime rates. In this light, Cameron et al. Advocate for comprehensive reforms within the criminal justice system, particularly the prison system, to enhance public safety and foster a healthier society for all. With regard to the accused's personal circumstances, several provided for his family, therefore a custodial sentence would directly threaten the family's financial security. He is the father of 3 children aged 99 and 7 and husband to his wife. As an actively involved parent with a strong family orientation, his absence would disrupt his children's and wife's emotional, social and psychological well-being. It is important to highlight that should the accused receive a custodial sentence exceeding 12 months without the action of a crime, he will be rendered ineligible to serve as a member of the National Assembly. This disqualification will persist for 5 years following the completion of the sentence, thereby restricting his ability to represent his constituency during this period. The accused enjoys notable support within the South African society, with many subscribing to his philosophy and expressing confidence in his leadership within key institutions such as the National Assembly. His removal from office would inevitably create a void for the communities he represents, potentially diminishing their voices and the hopes he has consistently championed on their behalf. Finally, the accused active involvement in community initiatives would be interrupted, placing the continuity and sustainability of ongoing projects at risk to the detriment of the community. Considering the facts of this case and the personal circumstances of the accused, it is necessary to carefully assess whether any form of imprisonment would constitute the most appropriate or just outcome. Evaluation. The purpose of the evaluation is to assess the risk of recidivism and to identify key factors that may inform and guide sentencing decisions. The following are considered protective factors which substantially reduce the risk of reoffending. Strong social support. The accused learned the importance of family from a young age, continued to maintain close family relations, and relies on the support of his family when necessary. Resilience, coping abilities, and thinking skills evidenced through a progressive career trajectory despite challenging childhood circumstances. Low risk in terms of criminal history. The accused, the 44-year-old first-time offender, committed the offence at the age of 27 and fully cooperated with court for 5 years. He has not reoffended since. Pro-social behaviour, as indicated by his active community involvement. The minor part of the sentence, any form of pain or discomfort an offender suffers as a result of committing a crime can be seen as punishment and moral retribution. The following is noted in this regard. The lapse of more than 7 years between the commission of the offence and conviction is regarded as a mitigating factor. Beyond the financial burden, the court in its decision acknowledged the considerable mental anguish experienced by appellants who endure prolonged uncertainty regarding their future, recognizing this as a relevant consideration, and humiliation and public shame having been already declared of having done something wrong. Although the accused maintains his innocence, which is often viewed as a risk factor, his recognition that a criminal conviction would undermine his ability to credibly promote respect for the law, notably diminishes the likelihood of reoffending. As a revolutionary, the accused frequently challenges established conventions, while his readiness to address perceived injustice may continue to invite controversy and potential legal scrutiny. These actions alone do not necessarily heighten the risk of him reoffending, unless future legislation criminalizes specific behaviors such as hate speech. Conclusion. Given that all 5 charges stem from a single incident and video footage shows that the accused did not load the firearm, it is recommended that the charges be considered collectively for sentencing purposes. After a thorough assessment of the accused's personal circumstances, the seriousness of the offences, societal interests, and relevant legislation in place, the following sentencing proposal is made. Impose a fine that reflects the gravity of the offences, with the fine suspended to encourage continued lawful behaviour. Restrict the accused from obtaining a firearm licence for a specific period as an ongoing deterrent. Require the accused to make a monetary donation as restitution to Gun Free South Africa, an NGO focused on reducing gun violence in South Africa. It is acknowledged and accepted that the duty to impose an appropriate sentence rests with the Honourable Court.
Revision report. The annex to your report, you also detailed your resources that you utilize in the compilation of the report and who you actually consulted. That's at page 36.
That is correct, Your Worship.
And then further, the cases that you cited in the report, the legislation and documents that you have regard to.
That is correct.
You also, as I understand your report, have regard to Her Worship's judgment in the matter.
That is correct.
And you've also done, as an Annexure 1, a background of your background as an investigating social worker.
That's correct, Your
It's
Worship.
on pages 39. When you take us through those qualifications, because they only touch on your illness, because I need to repeat them, this is in regard to your experience in professional membership of status. It's on page 39. So we've heard about your first three qualifications being a BA in social work, which you obtained in 1986, an MA in social work in 1999, and an LLB in 2005. You then have a postgraduate certificate in econometric assessment in 1999, Perspective Training College, and you were certified Indiana Grant Practitioner from 2023, a procedure that you referred to in this report.
That is correct.
Could you take us through 2.2, please, your professional membership and status?
I am registered as a social worker with the South African Council for Social Service Professions, with my registration number noted. I'm also a member and a member of the International Executive Board for the South African Associations for Social Work and Private Practice. I was admitted to practice as an advocate on 21 August 2006, however, never practiced, and is a non-practicing member of the National Bar Council of South Africa, and also registered as non-practicing in the Legal Practice Council. I've been appointed as a member of the 5th Professional Board for Social Work in 2022.
Those are your memberships. Can you take us through your experience?
So I've been practicing as a social worker since 1987. Started my career at the current South Correctional Services Facility, and it was interrupted thereafter doing work at a church and family organization. I have thereafter worked another 6 years for the Department of Correctional Services. During my department with Correctional Services, I worked with sentence offenders and both in prison and serving community-based sentences. And with the introduction of correctional supervision as a sentencing option, I established the function rendering these reports to the court for the Wynberg and Wynberg Magistrates courts at the time. I have, since my resignation from the Department of Correctional Services in 1999, continued to do pre-sentence report and a part-time capacity in my private capacity.
When you have further additional fields of expertise, it's include children's court investigations, family mediation, student supervision, supervision of student supervisors.
That is correct, Your Worship, and alongside the part-time private practice, I've also worked in the corporate environment where I have been trained and had extensive experience in risk management, which I find to be contributing beneficial to my work as a social worker.
And you were employed previously by the Department of Correctional Services for 9 years,
That is correct.
and the Christian Social Council for 3 years.
That is correct, Your Worship.
And it says here, with 26 years of private practice experience, mostly in a part-time capacity.
Correct.
You've then given a list of matters in which you provided pre-sentence reports. It's on page 40, is that correct?
That is correct, Your Worship.
And then at page 41, in annexure to refer to in the report, and you refer to sentencing credits, where you had regard to particular reported and unreported cases, and the convictions, circumstances, and sentences that were imposed in those various cases.
That is correct.
And that will take us through to page 42. Is there anything else that you'd like to add in relation to the sentencing of this accused for this amendment?
Nothing to add to my report, perhaps just the observation, and I think during my experience and working with my teams, his respect and the importance of respect to him was always notable. And when I look at the setting active people. It seems like the
You're
elders,
returning, it's, no, I'm going to correct it because
the
I'm
elders,
sorry, you're speaking through the worship, but now there's a problem with you turning that out, it's impossible to hear.
sorry,
Can
Richard,
you
so
just repeat, I beg your pardon? If you can go back,
in the
please.
context of my experience of the importance of respect to the peers, when I just noticed the sitting in the court, it seems also that the elders, which is a very important community, and seeking this preference. It's just an observation. There's nothing else to be added to my report.
In other words, respect for elders.
Respect in general for people, but specifically for the elders.
Finally, what would your view in relation to incarceration in these circumstances that provided this method?
I think if I can summarize the views from my report, is that when it comes to incarceration, and I haven't done the detail or add any detail about it, but the reference to the book by Cameron, and it all deals with the circumstances in imprisonment, with the overcrowding of imprisonment, the need for and I continue, the need for reform to look at how we sentence differently, recognizing the place for imprisonment, but that there are certain matters where a custodial sentence would not necessarily be the only appropriate option, specifically where it wouldn't serve all the purposes of punishment. I think the preference would always be that imprisonment would be where prevention would be a key deterrent, a key purpose of punishment. But other than that, I think the circumstances of the case would take it. So when I look at this work, compared to the other cases of a more serious nature, there were no, I couldn't find any intent that the weapon was used or obtained with the aim of committing any other offences. It was specifically for the purpose of the celebratory shots. It was in his possession for a very, very short period of time, making it very distinguishable from all the other cases where a period of imprisonment would be imposed.
Aligned to that answer, there are two aspects that come to mind. Firstly, the issue of recidivism. You've highlighted in your report the fact that since the date of the commission of this offence, there have been no other charges of any nature leveled against the accused. Are you aware of any other incidents in which he's been cited or referred to as having been in possession of a firearm illegally or firing shots in public in an illegal manner?
For celebratory purposes?
For any purpose. Are you aware of him ever being involved subsequent to this event in the firing of any firearms thereof?
I'm not aware of any other cases being brought against the accused.
And then, finally, you've said it in your report, but I think something that requires highlighting. Were you, in your research, able to find any cases that dealt with a discharge of firearms in public areas in a celebratory event, be it one of a funeral and or an engagement or anniversary of some sort or birthday, with any cases dealing with sentencing in those circumstances?
I couldn't find any cases dealing with a person being accused or sentenced or any challenges of sentences or convictions in this regard. I have, however, seen warnings in the press where people are often warned about the risks and the seriousness about it, asking people not at New Year's at celebrations to do that. I also picked up an article indicating that at the funeral of the late Magistrates Mandela, afterwards there were shots fired from her home in a celebratory context. I'm not sure if anyone was arrested in that regard. I haven't found any information to that extent.
Thank you, Madam. I have no further questions. Thank you.
Advocate Caesar.
Tempted to start with my cross-examination, but I don't know, lost a few pages where the witness has testified, just for the sake of thoroughness and completeness, because I did get a report only this morning, to go through it again to ensure that I haven't missed anything regarding this particular report, because it is testified quite fast.
Understandably.
I looked at it generally, if I can, I don't want to say 15 minutes for the pages. It is each document. We also didn't have tea break. It can make it a little bit longer, maybe 20 minutes or so.
Okay, may we just discuss, so you mean to start, and then will you also inform me, will there be a lunch adjournment after we return, so that we can, you can't say no and spare advocacy. There's many that we have to consider. Okay, just keep that in mind. Will you just then please, since I'm not close, I don't know when you'll be ready, that a message be sent to me, please.
Yes, sir. I might be ready even quicker than that. I just need to be certain.
Shall we then say, I'll enter court at 12:15. If you are not ready or you wanted, they needed a tea
Yeah, by
adjournment.
12:15, you should, if I was ready before that, I would have you was a call.
Since you also said there was no tea adjournment and court staff did not have, let me enter at 12:20. If it's sooner, just send me a message.
Thank you.
If you're not ready at 12:20, I'll enter and you may simply inform the court. In order, Advocate Otis. Thank you. Going to change chairs when I come in. Okay. Thank you. Court will adjourn. Everyone ready for us to go back on record? Thank you. Our light is on. We'll just give the witness an opportunity to move to the witness stand. The witness, you are reminded you are still under oath in this matter. Advocate Caesar, before I continue to explain to the witness, I know she's experienced in this regard, but I still have a duty to do so. Are you ready indeed to commence with your cross-examination?
I am, Your Worship.
The witness, just as a courtesy, I always explain to any witness that cross-examination will now follow. Meaning the state will ask numerous questions from you. You are able to just answer as best as you are able to do. And also just please remember we are all writing down what is being asked and what is being answered, because it was easy to follow the typed report, but to write down what will follow is not as easy. And that's basically the extent of cross-examination. Thank you. If you're ready, you may proceed, Advocate Caesar. Yes, I've done. I reminded them.
Since you're also admitted as an advocate, non-practicing as well, should I be addressed? I'm going to read your report. I'm going to start from the last portion to the front, because it's the part I remember most, the last sentence that you gave. I want you to go to page 41 and 42. That's the last 2 pages of your report, where you basically stated the cases that you were involved in and the sentences that you were involved in. Firstly, I want to speak about 1, 2, 3, 4, 5. First cases on page 41. Do you still have the reports of those cases with you?
I don't have it.
It is interesting to see what how those reports were compiled in order for me to compare it with your current report. Because in most of these reports, in my experience, they are copy and paste jobs.
So are you not referring to the case here, but the matters I have done?
We can go to page 40.
Page 40, okay.
You're referring to
Yes,
work case.
correct.
of that particular court case that you dealt with?
It was a person charged of murder. He hit someone while sleeping with the stick handle of an axe. And within the circumstances, the person that was murdered was a family-related matter. It was a family member who has been, they used the word terrorizing his family, putting at risk the safety of his wife and children as well, and had connections in the sense that the person felt helpless and that there would be no help if he reached out to the police because of the deceased person's connections. And then there were, from the history, a number of mitigating factors that played a role and contributed to the incident where the murder was committed.
What was your recommendations in that matter?
The recommendation in that matter was to have a reduced sentence, either 2761I or 2761H, considering the circumstances of the individual, and considering some of the detail, the personal circumstances were considered to be substantial and compelling. So a deviation from the minimum sentence with correctional supervision, either H or 2761I.
So in other words, you recommended one of the sentences in a murder case. Basically, you recommended that a non-custodial sentence be imposed, one of the sentence options in such a serious offense, such as murder.
Considering the specific circumstances of that particular case, there were a number of other murder cases that are also done where imprisonment were recommended with a deviation from the minimum sentences.
Do you know if this court matter was ever taken on appeal and what was the outcome thereof?
No, I do not know.
I would have loved to know.
It is a very old matter, so I do not know.
Yes, because the sentence I find it from my experience, that is not usually the kind of sentences that are or imposed in murder cases.
Correct.
So in Lawton and Ranger, I see the accused was charged there with attempted kidnapping, attempted murder, culpable homicide. I think you are referring here, you said he was found guilty, accused 2 and 3, yeah, was found guilty, I think, of kidnapping, culpable homicide. Can you just give us a description as to what transpired there, if you still remember the facts of that particular case?
Well, it is, there were a lot of detail about the case. It was probably considered to be South Africa's first cold case, a murder case. And the charges were as is. The person disappeared and her body was later found, or the remains after a letter was found in a house that's being renovated confessing to the murder, and then the investigation started after that. So obviously considering this and all the circumstances, again, the case, the detail of the matter and circumstances of the accused, the main accused, my conclusion at the time was that imprisonment would be the only option to consider, a long term of imprisonment, considering the roles of the other two and what they were guilty of and what transparent. Still justified imprisonment at the time, but to a lesser period of imprisonment, considering also that the accused at the time, I can't remember the time, but they have been in custody pending trial for a very, very long time.
Listening to the facts, as you explained it, it's not that Rasuki matter where the lady was found after. Is that not the case you're referring to?
It could be she wasn't found. The remains were found after they have received the letter confessing to her murder.
Yes.
Yes.
Can you recall what was your recommendations? You said.
So I had a conclusion to say that imprisonment was the only a long-term period of imprisonment is the only suitable sentence option, with a lesser period of imprisonment for the two co-accused. Can't remember the detail of the words.
So you did recommend that a lesser term.
A lesser for the two co-accused, not for the main accused.
Which one was
The-
your client?
All three of them.
And you say you don't know what was the term of imprisonment it
I
was
think
imposed.
the term of imprisonment for the first accused, if I remember correctly, was 30 years. I can't recall for the other two, but it was less than 5 years, if I remember correctly.
Less than 5 years, and they were charged, you said, with culpable homicide.
Yeah.
Why would there be culpable homicide when this is actually a murder case that we're dealing with?
If one have to look into the detail of the case, it would, the court would have found, considering their contribution, that is what it would have been.
Apologize, there's a request to speak louder.
Oh, sorry, apologies.
Then I want to deal with the third case you're referring to Akub, where the person was charged with negligent use of a firearm, causing injury to someone, discharge of a firearm in a built-up area or any public place, assault with the intent to do grievous bodily harm, pointing of a firearm. I see this a conflict situation. It was probably your brief description of the situation or the facts of the case. Can you still recall that?
A high level, that's why I said a conflict situation. It was two, would I call it, rivalry families being in conflict situation coming over a period of time. And it arose, the conflict spread over to a public place, and where the incident occurred.
And I note, what was your recommendations in that matter?
I know it was one non-custodial. Whether it was specifically a fine, I can't remember. But again, considering not only the facts of the case, but also the personal circumstances and the mitigating circumstances of the accused. And after part of that, I can't remember all the detail, was also a lot of harassment from the other family to his family, a lot of harm and psychological hurt afterwards because of, I think, continued conflict. The case, when it was charged, didn't necessarily stop the conflict.
Would you agree with me? You have already now mentioned in 2 instances where serious charges have been faced by the accused, where your recommendations was basically either non-custodial, and in the murder one, you recommended 276 H or I. H meaning at home, you must serve it at home.
Correct.
I
Correct.
meaning you must serve it in custody in a murder matter, which means the maximum sentence when you do impose I is 5 years
Correct.
imprisonment.
Correct.
In this case, it's such a serious case, I see you note that the fine was 50,000 rand
Correct.
that the person had to pay.
Correct.
You're also referring to the Bezos matter. It says it's a private prosecution, assault with intent to do grievous bodily harm. You said it was a not guilty plea from the little note. I don't want to go through your full court. Do you know the facts of that particular case? And what was your recommendations relating to that case?
Shortly, facts were that it was domestic relationship related, domestic fight, and the wife was injured. The person wasn't prosecuted, approached Forum, and the private prosecution followed. And then considering, again, apart from the cases, so these cases here, there are a number of others that I've done where I was selected specifically because of although it's serious, the different circumstances to this case and the personal circumstances and mitigating circumstances, which were different from cases in general that you have, or the cases in general. I have dealt with numerous murder cases where it is really the purpose of deciding what are the compelling and mitigating circumstances, if any, that you put in front of the court without making any recommendations at all. These were when you look at the circumstances of the person and because at the end, when you look at it within the context of the triad of sin, the person's circumstances is also very important. So in these cases, there were exceptional personal circumstances and quite often the absence of pattern of either violence or the same type of behavior, which also had to consider, which informed the sentence suggestion.
So we're going to get you jumping the gun.
Sorry.
We're going to get to why you were asked to attend to these cases. I first need you to answer this question where I specifically asked, what was the facts of this case? What
Yes.
was your recommendations? That was the question.
It would have been non-custodial, but I can't recall the exact recommendations.
The facts?
Facts was a domestic incident of violence where the person was, the wife was injured. No prosecution followed. There was a long process prior to that, prior to her approaching AfriForum to do a private prosecution, which was done, and in which the person was convicted and a report was requested.
Also non-custodial. You said it's a female that was injured, who's the complainant in this matter, yet still you recommended a non-custodial sentence in basically in a gender-based violence issue.
Correct.
The fine that was imposed was 100,000 rand or 12 months imprisonment. And then you also note that 6 months correctional supervision, performed 20 hours community service at a shelter for for abused woman.
Correct.
What was the reason for you to make such a recommendation in instances where there was some domestic violence and domestic issues, that this was
That was
proper?
the sentence from the court. I cannot recall that was specifically my recommendation.
What was your recommendation?
I do not have the specific recommendation in front of me. Unfortunately, I didn't bring the cases with me.
It's also unfortunate. I also would
Yeah.
love to have a look at those
Reports.
reports. Then we go into Sekwati. We refer there as an arson, malicious injury to property. I also want the same question as before, your facts, your recommendations.
Facts of the case where it was an incident of a domestic fight. The wife was charged with setting the property alight, and it created some damages, and she was charged with it and convicted.
Yes.
Circumstances, primary caregiver, no other incidents of violence attacked, so it spread from the relationship, and a very difficult relationship that were done, and the recommendation again was non-custodial, specifically considering that she is also a primary caregiver of 2 children. At the time, she also, the one child was her biological child, the other one was a foster child. So giving further comfort that if she's been considered appropriate to have a foster child, there were not any other red flags making her a danger to any other person.
The sentence you said you recommended non-custodial because you've explained that she was a caregiver, and so regardless of the seriousness of the offense being arson and so on.
So I can't, if I recall correctly, the recommendation was a period of imprisonment suspended with a condition of correctional supervision. The court opted to still go non-custodial, but a different sentence.
Yes, almost to the letter adhering to your recommendations. Isn't that so?
That one was not really to the letter, but yes, it
It's
was close.
Do you know, I still remember a case, I don't know whether you know, during the feast must fall, one of the gentlemen took a petrol bomb and he threw it into one of the police vehicles, and he got 8 years direct imprisonment, if my memory serves me correctly, for almost the exact same offense that he committed.
Circumstances sound very different. It was, a fire was lit in the house. It was nothing to do with something. If we talk about the arson, there were no injuries and there were no one in the house.
My idea is that if you were the one assessing it, you would have had a much better outcome than the one that he had, where to serve actually direct imprisonment.
I wouldn't be able to say whether it's so because I do not have the details of the matter and his personal circumstances.
It's going to take me a while to go through this, but I want to do just the second page and then I
Okay.
want to stop there because it's quite a number of pages, but you already see where I'm getting
Yes.
at. Is that correct? Referring to Nene versus the state, where the accused was sentenced or charged with murder and reckless danger to a person and property. The security guard, can you just go again? The facts of the case, your recommendation.
What page are you in?
I'm now on the page 41. My
Okay, so on
apologies.
page 41, just for context, Your Worship, I looked at trying to find, I've previously already mentioned, I couldn't find any cases of similar to this one where shots were fired in a celebratory extent. So I was looking for cases where firearms were discharged and similar type of charges, although the context is different, to get an idea of what the sentences are. And this is just really to say these are the things that I looked at. It's not cases that I've dealt with.
Okay. But in the 5 that I showed you, you already picked up the pattern that I'm trying to point out to you, that you made certain recommendations and most of them were almost followed. Is that correct?
Well,
In very serious cases.
based on the cases that I selected to show there are exceptional circumstances, yes, that would be the pattern. If I had expanded the list and selected cases where the circumstances were not so exceptional, you might have come to a different conclusion. But I have not done that.
So it's only the cases with exceptional circumstances that are referred to you.
Some of them, there may be others. I had to have a look as to which were these type of cases where the circumstances were exceptional despite the seriousness of the crimes.
Do you regard the issue of the gentleman I just referred you to, about the one who was protesting for fees must fall, for free fees for students, in the heat of the moment, throwing a petrol bomb as he's running around, being a young gentleman, still a student, throwing the petrol bomb in the police van? You don't regard that as like those exceptional circumstances?
I wouldn't know because I do not have the full picture in terms of what happened, what contributed to it, what is his personal circumstances, which is a big part of what you look at. And I cannot comment with it without the full picture.
I'll try to get the full picture from council. I think there was a period in that matter for the leave to appeal application, Mr. Mukai Toby. But in those, the facts that I've just given you, you would not regard this as exceptional.
There are certain things that had to be explored. If it's a young person, it was in terms of specific cause that was followed. But other than that, as I say, it's not only about the facts of the case, it's really connecting the person with the facts of the case and looking at all together, which would make the exception, not necessarily the facts of the case only. Because if you look at some of the facts of the cases that I given, it's not that exceptional. The exception comes in when you add the component of the person to the case.
Do you agree that only the people with means would be able to approach you for you to actually compile a report because you need to be paid for work done, services rendered.
That is correct, that people need to be paid for my services rendered, but I also do need, do in exceptional cases again, I may do a report for a reduced rate to make it more accessible. And in general, my approach is to make sure that my costs are capped at a specific amount and that it doesn't exceed that amount to make it more affordable for a wider audience, irrespective of who the person is.
If it wasn't in court, I would have been so tempted to ask you what that rate is. You don't have to answer. But the point that I'm trying to make is only people with means are the ones that are able to approach you. Those who can't afford it will end up in prison because they don't have the benefit of your comprehensive report with your LLB and all your qualifications.
People with limited means would also be, I have been approached previously for cases where I have accommodated that on request of the legal representative to do a report at a reduced price for people with limited means. And yes, even though you do not want me to state the specific amount that I generally ask, I can confirm that it is, for my appearance, the court, the investigation, everything, it is below 20,000 rand, way below.
I want to go to your conclusions in this particular matter. We are going to page 30. Let's start at page 34. Yes, page 34.
Okay.
I want you to go to the conclusion where you said they basically given that all 5 charges stem from a single incident and video footage accused did not load the firearm. It's recommended that charges be considered collectively for sentence after a thorough assessment of the accused's personal circumstances, the seriousness of the offense, societal interest, the relevant legislation and case law. The following sentence proposal is made. Impose a fine that reflects the gravity of the offense, with the fine suspended to encourage continued lawful behavior. 91.2, you said restrict the accused from obtaining a firearm license for a specific period as an ongoing deterrent. And 91.3, you said require the accused to make a monetary donation as restoration to gun-free South Africa, NGO focus on reducing gun violence in South Africa. You are recommending that the accused pay his way out of jail in this conclusion. Is that not correct?
What I am concluding is that jail may not be the necessary approach to go. There is a reason that there are fines. The Act prescribes the fines, and if one can then argue that every person who can afford it can pay their way out of jail, where it is one of the allowed options within the Firearms Control Act for these contraventions.
So the more affluent ones must remain outside jail, the poor ones must go straight to jail because they can't afford it.
I think that the
Let's set the ground rules right now and then. Right now. If you don't like an answer or the question, you simply leave, and no one will disrupt the court proceedings in any manner. You want to sit down and go quiet, you remain. The rest I will order to leave without exception. Understood? It's your choice. I won't ask again.
That's the impression that was created. You have an answer to that.
So, Your Worship, the fact that a person can afford a fine, if it's a severe fine, doesn't make it less of a punishment. And the converse of that is then where a fine would have been appropriate if you are an affluent person and can afford it. Should you not be afforded because of the perception that may be created and therefore go to jail, if there are other circumstances that would say maybe that is not necessarily the only option.
You, your question was asked, and I'm not sure of the way, but if you can just summarize for short, how can it
Apologies, Your Worship. Um, so, the, where the legislation provides for it as a sentence option, and if a person is affluent and the case is serious, a heftier fine can be imposed. The fact that a person is more affluent doesn't make it lesser of a punishment. It still is a punishment. And the converse side is then of this of looking at it is to say, if I am now affluent and can afford it, to avoid creating the wrong impression, should I therefore by default go to prison? Um, and that is just the converse of the point.
I'm going to read from some of the cases. I've made a summary of it, whole summary of the cases because I was preparing basically for argument at the end. I'm going to put it before the court. I want to show you in certain circumstances where the facts are exactly almost very close to the accused case, where people have to go to jail and the periods that they have to go to jail. So I'm going to refer you to that. If I may just hand this up, Your Worship, at this stage, I did give Mr. Kaitobi a copy of my practice note.
Do you want to start on that point now, or are you going to have a shorter lunch time?
I need to welcome everybody.
Yes, then the court staff and media, I need to observe
I
all
mean,
the
the
rights.
court says this is an opportune time, I have no objection to taking this phone
Yeah.
now. Confirm, it's not a practice note, there's an article which is handed to my colleague, Mr. Toby, by the prosecutor. I haven't read it as such, I've actually bought it. It's actually referred to in the witness's report as well, so there's no objection. There's a continue for the one I don't understand what the nature of the request is, was they handed to Mr. to read it, it's up to me.
So would you like also to read the document before?
I don't need to read the witness is read it.
Look, I'm also as eager as anyone just to continue, but I have to observe the rights of everyone in court, and we may need a refreshment or to eat or what. So do we decide on an hour or do we shorten the period? The state, we can inquire, maybe we just pause the record for now because it will just be cluttered with us deciding on time. The media is still on, it's just the record that's on. Okay, may you just please give me an indication? The media may also speak up. Only once.
Of course, one.
Everyone in agreement say yes, everyone not in agreement be quiet.
We agree.
Of course, sorry?
Of course, I will agree with you.
Okay, fine.
Take it back now.
Suitable for everyone? Going. What did you really
of my notes, the notes that I have with me in respect of a particular case, State versus Asma. Uh, it's the second paragraph on page 11, referred to as State versus Asma. Most of the references are the footnotes, in case your worship wants the citation of the particular case. Page 11 of the document I handed up. Yes, okay, page 11 is on top. 11 is right. I did ask the court order to hand your worship a copy. I was going to use this during arguments, say page 11, the second. Citation is at the footnote. State versus Asma. I'm going to tell you, the Supreme Court of Appeal referred with approval to Marikani when it imposed an 8-year sentence for the possession of a fully automatic firearm, which also resorts under the minimum sentence regime. Chongwe found that the minimum sentence was shockingly harsh. He was sentenced to 15 years. Shockingly harsh, and I'm going to tell you now why he found that, because of the facts of this particular case. He found that the minimum sentence was shockingly harsh and disproportionate considering the facts of this case. The unique facts of the case were that at the time when the rifle was found in the appellant's house, he had already been incarcerated. The rifle was not loaded on a horse there. The rifle was not loaded, it did not have any ammunition in it, and no ammunition was found. Further, it had not been used in the commission of the offenses for which he had been arrested. The felon had failed to proffer a reasonable explanation for the possession, save for a bad in hand. I'm going to explain to you why this case is very similar for a very short period of time. In this case, it was a fully automatic firearm because it was a rifle. This one was a semi-automatic rifle. But this one, in this case, had ammunition in it. And the facts you referred earlier to. First, I want to hear your comment on that, and then I will get to the actual facts that you referred to. Do you have any comment? Is it similar to the situation?
Part of it would be to understand how he got hold of the rifle, what was the purpose of getting hold of it, how did it get, it was a really short period of time, but it was in his possession, so it probably stayed there while he was in prison. So although there may be similarities, if you look at the whole situation, it is not exactly the same.
Emphasis on having it for a short period of time. Is that correct?
What was the period? Is the short period a month, a minute?
I'm going to assist you now. I'm going to go to a next case where they actually indicate how long the person had the firearm in his possession, which similar sentences were imposed.
Okay.
Where did you get the facts of this case? Did you follow the case? Or how did you manage to get a hold of the facts of this particular case?
So part of it was looking at the videos. I've already done most of my report when I got the copy of the judgment, but I scanned through that as well. But prior to that, I looked at the YouTube videos. Sorry, Your Worship, my fault.
That is correct. I'm referring to this particular matter, this case that she testified.
I initially, Your Worship, listened to the YouTube videos. I was almost done with the report when I got the copy of the judgment, so I have really scanned through it, but most of it initially was through the looking at the YouTube videos.
You refer to one spent cartridge. Are you referring, when you say one spent cartridge, are you referring to that he only fired one shot, or are you referring to the fact that he was convicted of that one?
That was what he was charged of and convicted of.
Where you've seen the videos, that's correct.
Correct.
You are aware that he fired actually with two different firearms, and with the one firearm, approximately 14 to 15 shots were fired with a handgun, and then with the firearm, the other one, the rifle, 7 shots were fired. Were you aware of that?
I saw the video where the celebratory shots were fired, Your Worship. There was no other charges relating to a firearm relating to this matter. So I focused on the charges in front of the court in this matter. If there was anything else, to my knowledge, there was no charge relating to that.
The evidence, both videos went in. The evidence showed that he fired with two firearms.
And it's perhaps, Your Worship, not for me to ask questions, but I can also not recall that there were ballistic evidence linking the other firearm to the accused.
Regardless, you saw the video, more than one shot than there was. Is that not so?
That is correct.
Your report, did it only focus on the one shot that was fired, or did you look at the totality of the shots that were actually fired on the day in question?
I considered that shots were fired for celebratory purposes and that it could have harmed people around the environment.
So I'm informing you now, it's approximately 22 shots that were fired. Would your report still have been the same, regardless of the number of shots that were fired?
It would still be the same, considering the other factors, that there was no evidence further that that there were any harm done to property or people or any complaints from people around. If they were, it would have been different.
That you noticed on the video that just prior to the accused, when he started the firing with a rifle, in fact, when he started firing with a handgun, there were 7 people standing there in the direction that he was firing to, and they were running away, or despite him disputing that.
Your Worship, the video wasn't very clear. I haven't noticed that.
If you were aware of that, would you have considered it and put it in your report?
That some people were scared. If there were evidence with that regard, I would have considered it, yes.
Yes. But you did not notice that. In other words, you did not consider it.
And there were not evidence in that regard that for what reason the people ran. I don't know what the reason might have been. It could be that they were scared. It could be for other purposes. I don't know.
It was very obvious. We didn't see it. It was very obvious why they were running.
It would be a consideration, but part of that, again, would be coming back to the considerations in terms of that's the potential harm, that people could have been harmed, that people were scared. But the actual harm in the end, Your Worship, is that there were no injuries and facts which would have been a much more serious consideration and contribution if there were actual harm.
According to the accused's own evidence, there were about 20,000 attendees. Some of them were just standing right there in front of him during this incident, prior to him firing those shots. You saw that in the video.
It was a big event to my knowledge, yes, Your Worship.
Have you factored that in into your report, the fact that there were actual people right there and the 7 in the direction that he was firing shots at?
Unless I've misunderstood, my understanding was that the shots were fired in the air and not at people directly.
I'm no ballistic expert, but the expert did testify what goes up must come down.
Correct, Your Worship, but there is a difference between firing in the air and it comes down. The potential is still there, the risk is still there that it can cause damage, it can cost life, but the risk is different when I fire and it is going in the direction of someone.
I just said to you, there were 7 people standing towards the direction, despite him firing in the air or not, towards the direction that he fired the shots in.
Your Worship, my understanding of the direction is, do I fire it directed at the people, or is it even I'm directing at Your Worship, but it's still fired into the air? And if there were ballistic experts indicating the come down would have been on those people, it might have been different, but the fact of the matter remains, whether it is the people in the stadium or whether it's the people of the neighborhood, when it comes down, people could have been hurt and people could have been killed, and that remains serious.
Are you aware that the Sisa Tikasu Stadium where the incident occurred is in a very condensed, right in the middle of a community, very condensed community, right outside, it's houses right around that place?
I am sure there were people around because the charge sheets were also very clear that it's not only the people in the stadium, but also the people working there, the supporters, the people from Beer House, and the people from the Ndansane community that could potentially have been impacted by that.
Did you appreciate the nature and the danger that was actually present at the time when the first shots were fired? The possible harm to others, the degree that harm could have caused if somebody did get injured.
I did indicate in my report as well that as part of the seriousness, not only injured, it could have resulted in the loss of life. It is serious.
So no thanks to the accused, that it's fortunate that nobody died.
I agree, it is fortunate that nobody died.
After now sketching the scenario, do you still maintain your report as to that we should either pay a fine to a gun NGO, gun-free NGO, and so on?
Your Worship, when I look at the scenario and the charges collectively, the accused acted negligently and didn't consider the risks, as was stated. There were no harm done. If there were harm done, yes, I would have considered it differently, because the potential harm was there, but no harm at the end materialized. The act was still negligent in causing the potential harm.
Negligent or reckless?
Reckless as well, both the charges state that.
I'm going to go to page 15 of the report, not your report, the one that I've handed in, because we are discussing cases of a similar nature.
Okay.
I'm going to start reading from paragraph 2 of the document, page 15, Your Worship. It's referred to as the Swartz case, if the reference is there. At the footnote, the appellant was convicted on 2 counts of the unlawful possession of a semi-automatic firearm. The court confirmed the minimum sentence of 15 years on one of the counts, in view of the fact that the appellant had offered a denial of possession, which denial was found to be false, and furthermore, that no mitigating circumstances in relation to his possession could be inferred. The court held that there was nothing to place, the court held that there was nothing to place his unlawful possession of the firearm in a less heinous light than that which motivated the lawmaker to lay down the minimum 15-year sentence. However, on further count of the unlawful possession of the semi-automatic firearm, the appeal against the minimum sentence imposed was upheld and replaced with a sentence of 7 years imprisonment. In this regard, the court held that the state accepted the appellant's version to the effect that he cautiously came across the firearm in a rubbish dump and was apprehended the same day. The appellant's decision to take the firearm into his possession could be regarded as having been made on the spur of the moment. Spur of the moment. Furthermore, it found that the appellant did not have the firearm in his possession for a very long time before he was apprehended. The court held that the circumstances of the crime were such as to make a sentence of 15 years in prison disproportionate. In other words, he got 8 years. Also had a firearm in a very short period, semi-automatic firearm, didn't use it in any offense, and so on.
And the other count?
The other count was, one was upheld, one was set aside.
So were there 2 firearms? I'm just trying to understand
Yes.
the context of
There
the
were
whole
two
of the.
firearms, the one who was sentenced to 15 years, one of the firearms were reduced, the one that we actually found in the rubbish dump. So it was a spur of the moment decision by him. It wasn't that he hadn't had it for a long period of time. Still, he got an 8 years direct imprisonment. This case, the accused also did not have the firearm for a long period of time. It's very brief. It doesn't change the fact that he was still sentenced to a direct imprisonment. What do you have to say about that?
Your Worship, what I hear is, again, different circumstances, although it was also not for a long period of time. It was, I wouldn't know why the reason is why it was picked up in the spur of the moment time, but I also hear that it was not the only firearm that was possessed illegally, which makes it different, and the use. I'm not sure whether the other firearm was used, but in combination, it is always good to look at it in the circumstances in total. But I hear what was said. But for me, the circumstances, again, are different. I'm not sure whether it was an illegal firearm, whether it was seized to the state, what happened to it, which may also make it different.
Did you come across any case where, like such as this, in the firearm related case, possession of firearm, where an accused was not sentenced to direct imprisonment and actually given a fine and to pay to NGOs and so on and so on?
As I said, I haven't come across, Your Worship, to any case where a charge was laid and the firearm was used for celebratory shots.
Have you come across a case where an accused was convicted of being in possession of a firearm, whether it's for celebratory purposes, whether it's just social, whether whatever reason? Have you ever come across the case where an accused was not sentenced to direct imprisonment for being in possession of arms, whether it's for just for a minute, or 10 minutes, or 20 minutes.
Your Worship, I have not. Most of the cases that I've seen were also not only the firearm possession case, but most of them relate is in the context of other crimes that were committed with a firearm. So the possession forms part with that, and then a sentence of imprisonment is also imposed for that. I haven't come across a case where it was purely just for the possession of a firearm.
Thank you for that submission. But in this case, other crimes were committed, shots were fired, reckless endangerment. You saw the different charges, trying to take precautions and so on. So, isn't that basically what you are saying?
So, Your Worship, if I refer to other crimes committed, I refer to, and some of the cases they may have taken it on the spur of the moment, but it is usually taken for the purpose of committing other crimes. And when I commit other crimes, it's violent crimes like murder, robbery, and in that context, you get the sentences being imposed. But I couldn't find a case where it was done and imposed outside of that context.
So the point I'm trying to make, how would that be fair to these accused that I don't want to go through all the cases. I just want to go to those who are closely related to the accused. How would this be fair to the other accused where these sentences being imposed but in this particular it's because the accused Stanley, he must now get the recommendation that he pays to NGOs and so.
Your Worship, the recommendation is not because of the accused standing. The recommendation is because of the very particular case that is different, where there were no other crimes committed in the sense of violent crimes. There is indications, I've mentioned it in my report, where part of the motivation to bring in minimum sentences for firearm-related things as well is because of the concerns with regards to the violent crimes committed with firearms obtained illegally. This is different from those matters.
How?
There was no intent to obtain the firearm illegally, obtain it from, and if I say obtain illegally, Your Worship, the accused didn't go out to get a firearm that is either stolen or licensed or unlicensed, keep it with the intent to go and commit murder or robbery or any other crime, as is in many of those cases that are stated. It's different in that context.
This evidence was to the effect that this was a pre-planned idea that this will be happening at the stadium.
The planning was at the stadium. The planning was not to commit an offence with the firearm. There was negligence in not considering the impact of that and the possible impact of those people, whether then from him or his people. But it wasn't done with the intent to keep it and to go and commit the violent crimes which inspired the extension of the minimum sentences regime to automatic and semi-automatic firearms.
I disagree with you, Ms. Thompson, with that sentiment because he did commit other offences. Like I pointed out, he's been charged for those and he's been convicted of that.
I do not deny it, Your Worship. I have made reference to violent crimes in the context of the minimum sentences regime.
I want to go to your report on page 33. I'm going to go to paragraph 87 on your report, where you say, although not part of the sentence, any form of pain or discomfort an offender suffers as a result of committing a crime can be seen as punishment and moral retribution. following is noted. A lapse of more than 7 years between the commission of the offense, the conviction, and all that and all that. You are referring now. I just want to point out to you, those gentlemen, the cases that I referred to you, they have committed a crime and they are doing or they do the time. So now you saying because because the trial was delayed and do you know the causes of that delay in the 7-year period?
I do not know all the causes of the delay, no, Your Worship.
Let me tell you, the accused wasn't immediately charged after the commission of the offense. There was an investigation that took place for a long period of time. The accused was sent with a summons. I'm not sure when was his first appearance. I speak under correction. I think it's in 2020. I just need to have a look at the charge sheet 2021. But during those periods, it was COVID. So the cases really couldn't really proceed. It only started after COVID eased a bit up. And the trial has been running ever since. The reasons for the delay is that we are not always all available at the time, especially counsel is busy, very busy. So how did that factor into the fact that you are saying it's a 7-year delay, whereas it's not really a 7-year delay, as I just explained to you?
Did you just see how I worded it? I indicated that it was a 7-year period from the commitment of the offence to the conviction, including all those things for the thing. But irrespective of the reasons, the reasons why it was delayed, it doesn't mean there's not an effect on a person, and that is what I was highlighting, that lengthy cases or cases that go over a period of time have an impact on a person, which is just that consideration.
You also referred to the humiliation suffered in public and by the fact that he actually appeared before court and so on.
He was convicted by the court, and the humiliation comes from that perspective. Apologies, Your Worship. The conviction the humiliation comes from the conviction. He was convicted of a crime, and a person in his position where he also would want to encourage people not to commit crime, young people, it impacts his credibility to do so.
Did you take into consideration the fact that he was actually the author of his own misfortune the moment he decided to take that firearm and fire those shots? In fact, firearms and fire those shots. He was the author of his own misfortune, so how must that now be beneficial to him? How must he benefit from that?
Your Worship, and that's exactly why I have mentioned that it is as a consequence of that action that you take that certain things happen that impacts you. It may not have been intended, but and that is the moral retribution. It is a consequence of your own actions. He doesn't deny the fact that there were an impact on a person, and that would go for any other person in a matter that one would consider as to what was the outcome, the combination of the circumstances, looking at the person and the case.
You also said that also one of the reasons is that the accused wife and his children and family might suffer financially because the wife is a stay-away at home wife. She basically received an allowance from him. That is also part of the considerations that you have taken into account. Is that correct?
Your Worship, what I have indicated is that when imprisonment is a consideration, there are implications. When we remove someone from society, it has a ripple effect not only on the family and immediate people, but also on society. And it is part of the personal circumstances of the accused that is considered in the triad of sin.
You does reside in Sainton, is that correct?
That is correct.
Have you ascertained his financial incomes, where it comes from, and how is he able to support, apart from his 1 point salary? I don't want to mention a specific amount, 1.5 million.
Your Worship, I did not. If it was a case for fraud, there would have been a much stronger focus on assessing the finances and how these things work. Irrespective of the financial status, he currently earns a regular income, and when that is removed, it has, I didn't say they would be homeless or anything like that. The reality is that when an income earning person is removed from the family, it has an impact on the family.
Do you know where he got the 200,000 as a donation to his school? I
Apologies.
think you said in your report he
Yes.
donated 200,000 to his former high school and so on. Did you establish where that money came from? How was he able to?
Your Worship, it was not to his school, it was to a NGO, a society working with children, that he made the donation. And looking at, in the beginning of my report, I also indicated when I delve into certain things, it looks at how is it related to the case, the finances, how it would be related. So on a matter of confidentiality, if I explore everything that is out there, which is not really that relevant to the case, it goes on to soliciting information that is not really needed for what I want to do, which would be not a correct way to go.
Should you not have, because there's now, in this instance, there's a real possibility that the accused might go to prison for a quite substantial number of years. So should you not have investigated that issue, since you have brought the family needs and so on into the occasion?
Your Worship, that is the consequence of imprisonment for any person that gets sentenced to prison, that there is an impact on the family. For some it would be worse, and for some it would be others. And the important fact is to highlight that there is an income loss, and there is a possible impact on the family from that perspective. So it may be worse for some families than for others, but it certainly impact the family and their way of living.
The age of the accused wife, if you determine that, his wife, how old she is, and whether she is employable, should the accused not be around.
Your Worship, that is in my report. I have indicated that she is currently a full-time person, but that she is, that her career, she paused her career to look after for the children, and that she also prepared herself for re-entry into the career. And listening to the question, I never said that they would not be looked after. I just said that there would be a financial impact on the family.
Why did you not say that they will not be looked after? What do you mean by that statement? I need you to clarify that.
So, coming back to what I said previously, Your Worship, depending on the family and their circumstances, the impact financially on certain families may be more devastating than on other families. But there is no situation where there is no impact if a person who is the main financial provider at the time is removed from the family.
I want to go now to the issue of remorse that you refer to page 19. he is correct that the accused is not remorseful for his actions. He's not being taken. He has not taken responsibility for his actions. He's, what I want to put you is remorseful that he got caught on camera.
Your Worship, I did not say that the accused is remorseful. I indicated that he maintains his innocence, which is often seen as an absence of remorse. What he does regret though, is the consequence and the outcome of the situation that people see, may see that he encouraged reckless use of firearms. But I didn't indicate at all that he said he's remorseful for what he did. He regrets the consequences.
Yes.
And there's also a difference between regret and remorseful.
Is remorse not one of the factors that should be taken into consideration? In fact, a very important factor when it comes to rehabilitation and deterrence and so on.
So, Your Worship, when it comes to remorse, and it is usually not, when a person is remorseful, it is considered a mitigating factor. When a person pleads not guilty, and because of that is not remorseful, that is not necessarily an aggravating factor. But when it comes to the link between remorse and rehabilitation, it is, from my experience of working with offenders, and specifically people serving custodial sentences, it is not correct to say that the lack of remorse by pleading not guilty at sentence is an indication that a person cannot be rehabilitated. Your journey that you will walk with that person is different, and it's really based on a very basic principle of social worker that when we talk rehabilitation, you always start where your person is. And if the person says not guilty, he doesn't, is not remorseful and is not guilty, that is where you start. And from there, you look at your rehabilitation journey. But it's not an indication that a person cannot be rehabilitated, because when it comes to a plea of not guilty, for that purposes, there could be various reasons for it, which is not always known at the time. And I think a very good reason, or a very good example recently also hitting the presses, was in terms of the murder of the late Mrs. Marika de Klerk, where the person convicted of the murder has been seen as very unremorseful. He pleaded not guilty. Later, as of recent, there were indications in the press where he came to the fore to say he actually did do it after denying what was the reason for not guilty. And that is part of a journey. So it doesn't mean a person cannot come to that insight. It doesn't mean a person cannot be rehabilitated.
He said he was embarrassed because he and Mr. Kerr were so close. She really, really liked him, apart from the other security guards. That's why he felt so embarrassed. That's the reason why he said he didn't want to admit to that.
Correct. But to my point, Your Worship, is that there are various reasons why it could be. And at the time, if one would have spoken to him, he would also not have mentioned that. He would have denied his guilt. And there are very different reasons. And when it comes to, the point is again, when it comes to rehabilitation, the fact that a person does not accept responsibility, does not admit guilt, does not mean a person cannot be rehabilitated. Although in the matter of this accused, I have indicated that rehabilitation wouldn't be a primary focus.
In this case, the accused was caught. You looked at that video, you saw it, yet he's still denying it.
Correct, Your Worship.
So for what you've seen, those shots were indeed fired, correct?
That is correct. I do not deny the court's verdict and that the accused is guilty. What I am saying, looking at all the circumstances, when I look at rehabilitation, that would not be a main consideration in terms of sentencing.
is your practice situated, Mrs. Thompson?
In Johannesburg.
How many consultations did you have with the accused prior to you compiling this report?
As indicated in my report, Your Worship, I had 3.
Where did these consultations took place?
The first consultation was at my office. I arranged a consultation at my office. The second consultation was at the offices of the EFF. And the third consultation was at his home in Polokwane.
The first consultation, how long did that take?
It was probably about an hour and a half.
Would you consider that enough time to make a proper assessment of the character of the person that you have seen before you, especially in the light that he was basically a stranger to you?
Your Worship, when we do these assessments, it's a combination of sources that you put together. Part of it is the consultation with the accused, and then it is consultations with collateral witnesses to obtain additional information and to also confirm information that you've obtained. And we would, from my perspective, I would never do one consultation only.
I'm going to get to the correctional sources. You are jumping the gun. The question was that sufficient time, an hour and a half, to make an assessment of a person who just arrived in your office? Basically, both of you are strangers to one another, and he knew exactly why he was there, that you had to draft a report, hoping probably that you'll draft a favorable report. The question is, was that sufficient and adequate time?
Your Worship, no, it is not, and that is why an assessment is not done on the first interview only. The first interview usually focuses on starting to get information, get to know the person, explain the process, explain the expectations, and to explore other information and resources that I might want to speak to.
So basically just getting a little bit of background, like when you go to the psychiatrist's office, basically they want to know who are you, where are you coming from. Is that?
No, it is a very structured approach in terms of what information you are looking for when you start, and then in the subsequent interviews, obviously you test information, you build it, you get all the bits and pieces of the information.
Please share. You said structured approach. We don't know what that approach is. Can you explain that?
So the structured approach would be to determine beforehand what is the information that you would want to have, and what you would want to obtain in the first interview. It's to sort of get Your Worship. Sorry, Your Worship, and I forget to turn to Your Worship every time after a question. The structured approach is really to have a layout as to what is the information that I would require at the end to do my report, and what should happen in the first instance, because it is important that the person know what is expected, how the approach will work, and what information I will have, and whether there are other people I would want to speak to. And then in terms of the approach, it is done through questions, but not questions in the sense of interrogating a person. It is really a discussion around that questions that generate discussion to get information, but also get an idea of how this person operates, who he is.
In this instance, what happened? Because you are now describing the general practice. In this instance, what was your aim? What did you do with the first consultation?
My aim was to explain to the person the process. My aim was to obtain information in terms of starting with the process, information in terms of his life, where he's coming from, his background information, and further to obtain information in terms of who are the people that I can speak to, that he can give me the contact details. I would like to speak to his wife. There are friends or colleagues that I would like to speak to. Who can I speak to? And that is the standard approach that is followed for all other cases, and that was the aim of that session.
So in other words, the information that you got who to speak to, which collateral sources to speak to, you got from the accused. Is that correct?
Your Worship, we always get it from the accused. We can ask specific questions to help in selecting the people we can speak to. Because yes, because it needs to be people that is familiar with the accused, that know the accused, that would be able to answer and speak to the questions that we may have. Yes, so we always do that with the input from the accused.
And the people that he gave you, it's basically his wife, you said, his two employees, the names.
I always speak to a partner if a person is in a relationship. So that was my question, my ask. So I need to speak to your wife, not he gave me to say speak to my wife.
The other two, what you said was his friends.
There were two that were friends that know the family quite well, that also grew up with him from, so they're coming from the same environment where they grew up, who's known him since childhood.
And two of the employees.
Two of businesses that where he is involved with, that he, yes.
They rely on those two.
Those two people actually, I met with my visit to Polokwane. He didn't necessarily give me the names, but because I met him, I also used the opportunity to have a discussion with him to obtain information, to check information, and to verify some of my information. So, no, the names didn't actually come directly from him. It was an opportunity that arises.
Yes, but they are employed basically by him, right?
They work with the businesses, yes.
Yes. I'm sure they must have glorified him because they are dependent on the accused, those two that you spoke to. Is that correct?
Well, my experience was that they answered my questions truthfully in terms of how they experienced the accused, but also in terms of general, the community. As I mentioned, I also speak to people to verify information. So some of the information I have asked of them is about the community and the community where these things are, these businesses are. If I observe something, I would ask, but what is this about and how does it work? Those things also in the bigger picture gives you an idea of who the person is.
They would be affected if the accused is not around. Is that correct?
One can say they would be affected, but the feedback is also that they run with these businesses, so the accused is not that much involved. So in the long run, it may impact sustainability of businesses, but they can also, because of their positions, continue to run with it. So I've never received the information to say if he is not around, the businesses will go down, but rather than there may be an impact because there may be guidance required, but that they can independently run with it for a period.
The wife would definitely be affected should he not be around, correct?
Well, he is in a relationship with the wife. It's part of the support. It's not only financially. And if you remove someone's partner from for whatever reason, it always has an impact.
The second interview said took place at the EFS office, is that correct?
Correct.
You only spoke to the accused when you were there.
I spoke only to the accused. I had an informal discussion with the person, I think, supporting him and who was arranging my access to the building. But that was an informal discussion. My purpose going there was to have an interview with the accused for purposes of my report.
How long did you spend there?
I'm not sure, but it was at least 2 hours.
The last one, how long did you spend with the accused?
Probably at least an hour.
You said 2.5 on my maths. In total, you spent 5 hours with the accused, if my maths is correct.
More or less, yes.
Yes. You think that is adequate time to make a proper assessment of the individual that you, and I'm not talking about constant 5 hours, as you've explained, it's an hour and a half, it's 2 hours now, it's an hour. You think that is proper or adequate time to actually say that this person is a good person, this is a bad person, when you've spent basically an hour or two per session with a particular person?
So, Your Worship, the aim of it is to obtain information about the person, where that partly comes in, but also his personal circumstances. It's not to determine whether it's a good or a bad person. It is to indicate which things are at can risk repeat offences, which things can mitigate that, and also to indicate if there are any factors to be concerned of, to be considered. It is not to make a judgment call on the character of a person as to good or bad, but looking at all these things, and that's why it is not only, we do not only rely on the interviews with the accused, and that is why it is also not a fixed session of 5 hours, but obtain information, see what you further want to know, see if there are certain things that may not make sense, and speak to other people to get information, but also to validate and certain things to clarify if I have certain questions. So it is a whole process that is followed. It is not just I am meeting a person for 5 hours and I make a decision, and you base it on the information that you have to do your assessment.
I want to treat you that 5 hours is inadequate for you to compile a report like such as this, as if you are saying that this particular person is it, because you spoke to a few friends here and the wife on the other side and employees, which I do not think is the proper sources that you should have consulted other than the wife.
Your Worship, from a social work perspective, the starting point is always with the person, because that is who it is all about. And the best way to get to know a person is through the eyes of others, because obviously you do not get information from other people prior to having spoken to the accused itself, because you wouldn't know what to look for, what to listen for, what to ask for. And similarly, I wouldn't necessarily know what is the process that a prosecutor would go through to prepare for a case. I think similarly, other professions wouldn't necessarily know the detail of the processes that we approach in terms of getting that information. And for me, I will sometimes, depending on the case and the person, because people are also different, 2 hours or 3 hours may be sufficient to get a very good idea. For other people, a longer time may be required. I will obtain and solicit information until I'm at a point that I feel what answer I'm comfortable with and I can comfortably speak about it. Until that point, I will continue to research, speak to the person or collateral sources until I am comfortable that I have a very good idea as to what I can, of the information that I bring to the court.
What did you expect these people to say, the wife and the 2 employees? You wanted them to bite the hand that feeds them, basically.
Your Worship, I did not expect them to say anything particularly. I do expect them though, and I always explain that to the people as well, what is the purpose of my questions, to answer honestly and to give me the information.
I'm about to finish. You also referenced the issue about the cross-examination. I'm not sure what was your specific wording regarding his cross-examination, how he conducted himself.
Yes.
I didn't get to understand what you meant by that.
So, Your Worship, what I have indicated that when it comes to the accused's motivation, the things that drive his behavior is a need to be right, to make a difference, and to protect people. So when he sees wrong behavior, he will address it, and he wouldn't hesitate to do that. And I think there are ample of examples. When he addresses an issue, when he has a discussion or a debate, he are generally able to contain himself, to focus on the matter at hand, to take personal matters aside, and to get the answers what he's looking for in that matter.
How would you describe it?
However, and that is my description. However, when it comes to certain matters that links to what he sees as right or wrong, if he perceives it to be wrong, if it's a matter that he is very passionate about, like respect the dignity of people and those type of things, and people touches on that or he perceives a wrong, his behavior may be different, and people will see that as, and that is what I was explaining to say. He will address it at the issue. He can be seen as
Aggressive. Is that the word you're looking for?
No, it's for people may see it as aggressive. It's not necessarily aggressive. It is you will see frustration. Just need to get the exact wording, but you will receive a reaction and he will act out. And that is what I mentioned, and that was what also was observed on the cross-examination, and it was also observed when he addressed the people after the conviction. He would make remarks that would either try to address what he perceived wrong at the time, and he would react to that, or you would pick up the frustration with that.
Thompson, I want to put you playing with words in a fancy way. The accused, do you perceive him as rude after watching all that? Aggressive, bit of a bully?
It's irritation and frustration that was coming through, and sometimes self-righteousness where he feels that he's right and it's his point and he's the one that's right.
That's your fancy way of describing it.
That is how I perceive him, and also how I've experienced him.
Lastly, I just want to go to your report. I just need to see where it is where you describe how the accused does not like noise and so on. He brings noise wherever he is. So what do you say about that?
Your Worship, I didn't say he doesn't like noise. I said he's sensitive to it. So if the noise gets too much, he will afterwards have to have a period where you just quiet down, do the things that he does to just quiet down. So he will not be the person that you would see that is surrounded by noise in a noisy space all the time. He will, he needs some quiet time as well. And you didn't say that he's noisy. You did mention he was bringing noise. I'm not sure what that means.
He himself is noisy. Would you not agree with me when he does do what you said, just describe, like the speeches, said outside after the appearances? And
when I say noise, it is noise in your environment, in the environment where you live. And in that context, I have put that context, you was within the context as to where he was growing up. That was a small house with many people, with a lot of noise. So when he's in his living environment and there's a lot of noise, he manages in ways to reduce that noise. And without going too lengthy into the theory, but quite often things that might trigger us, that we struggle with, comes from how we grow up or experiences that we have. So when it's in his home and his environment where he needs to recover, perhaps after a noisy day as well, he would prefer a bit of more solitude and quietness.
that you could have fooled me. It just proved my point that you did not have adequate time to assess the accused in order to come to such a conclusion?
I'm not sure what is meant, so I cannot comment on that.
Thank you very much. I've got no further questions on this witness. Thank you.
The re-examination by
Thank you, my lady, and thank you for the opportunity. You had as a child for over 7 years. Day number one to me, and only 4 hours. So I still have a lot of catching up to do. The accused instructed me to acknowledge the members of parliament from different political parties, the traditional leaders, the religious leaders. Yes, it's helpful to always bring a junior along to a case. Thank you. The students and the general members of the EFF and members of the public who are present in court. Perhaps that is where we should start in the re-examination, because your report references the impact of the accused, the positive impact to the general South African public, and the consequences of removing him from playing that positive role. You reference that in various parts of your report. Can you just expand on that? So sometimes it gets missed in these accusations of Mr. Malema being noisy.
Yes, Your Worship. In Parliament was it's a concern for the community and I would mention, for instance, coming back to the Zimbabwe as well. The dignity of people, for example, is really important to the youth, and part of that is to their living circumstances. So when I was before the colony, I had the opportunity to visit. We did a quick interview with Chairman Community, and it was I observed how clean the community was. And when I asked about the reasons for that, it is because it is one of the things that is important to go through. It is the need that was there for institutions that is run, but the details we want to pay attention to is, for instance, the time of the institution. That must be at 1500, considering that we may be going to school without having any food. Not all the schools in the community may have a food service. And if it's at 1500, they can either have an early lunch or a late dinner, early dinner or a late lunch, but at least they would have food to give them the strength to continue with their work after school. So there's these considerations, and I think we can make a contribution to the community. And then a part of it is whether people agree with these views or not. There is a community that subscribes to beliefs and see him as a leader and to his voice to those people. A big portion of them being people that are still unemployed, people that are still disadvantaged, and which one of these are not having a voice and to react people.
Thank you very much. I just want to expand on the answer you've just given, because it's relevant to a theme pursued in cross-examination, which is Mr. Malema is part of the elite, he's buying his way out of jail. But the report you've prepared actually paints a different picture of Mr. Malema as somebody who is a glue in the community, but also as someone who has a particularly unique interest in caring for the poor. Can you explain that? What explains his unique interest in looking after the interests of poor people that have no one else to look after them, and the impact it would have to send them to prison?
Your Worship, I think that focus on caring for the poor is a combination of his personality, the things that drive him, also being a protector of the poor and to do what's right and to help them. But that would also have been informed by his life story and the way he grew up. And very
Yes.
poor.
So just expand on that life story, because I think it's also been overlooked.
Part of the life story is two components to it. One is that he grew up in economically challenging circumstances. They were a poor family. He became involved in politics very early, and part of his drive for the politics was really when they started off very early and trained. What they were working for is a better South Africa if the apartheid regime had come to a fall. We are now, I don't know how many years into a new South Africa, and we want to look at statistics. Those people are still, there are still a lot of inequality, there's still a lot of poverty and people that are poor. And by the way he grew up, he continues to be a voice and to drive and try and change those people who have not seen the change
So we'll come to that second part, but just to deal with the first component where you said he grew up in economically challenged circumstances. Even that is sometimes difficult to understand what it means. But let me ask you just basic questions. Who raised him?
So in terms of he was raised by his mother, also supported by the grandmother. He was a single parent. The family did not have means, so and there were many people living in the house who didn't have means, so they had to share from a very early age the limited resources.
And where was his father?
He doesn't know who his father is. His father has always been absent. I think he's in search for who the father is for asking the mother and the grandmother to give him answers. So he still does not know who his father is. His father.
No, it is in the report. Yes. Well, my lady, it does emanate from the cross-examination, because especially the last questions that were asked about the personal traits and the personality character. Now, my lady, the only reason this is very crucial is because if you recall, when the witness responded, he said, what are the trigger elements to Mr. Malema? He said, it is the circumstances in which he was raised. Now, I'm asking, what are those circumstances in which he was raised? That trigger. Yes. I am totally happy to rephrase it as opposed to saying where it's, I'm not saying where it's his fault. I'm saying when he grew up, what were the circumstances of growing up? I'm very happy, my lady, to rephrase it that way. Can we then go back to this point because you mentioned that he has particular triggers that explain his behavior. Remember that he's being accused of being a bully. He's being accused of being aggressive. He's being accused of being loud, of being noisy. And then your response is you have to understand what made this man. And one of the factors is his upbringing. Expand on that.
So the upbringing was in poor circumstances. A number of people sharing a small house. Influential people with his mother and his grandmother. His mother had received a loan. His mother was a domestic worker, so the income was low, and some of the aunts had from time to time positions. He had a grandfather at his birth. He never knew the grandfather. He left the family, and he never knew his father. So he also grew up without a father figure, and really poor circumstances. And then at a really young age, he became involved with the preaching with the young pioneers of the ABC, with a better future, different circumstances for the vision should the apartheid regime come to an end. So, sharing with people, fighting for the poor, things that and growing up as well, union that they constantly do, both his mother and grandmother, despite his circumstances, and his whole that continues, and that is part of the broad and the voice for the people who are poor and disadvantaged.
Thank you very much. You then said there is a second component, which is his aversion to perceived injustice. Can you just explain that, which also drives his behavior that people may perceive as aggressive?
Part of that again comes partly to his personality, part of the upbringing. It is, and in terms of his profile, what drives him is looking at the world as a place where things are not always right and having to work to make the wrong right. And that drives a lot of things. And that is really just to give an understanding. I've also said in my report, this is used for coaching purposes to help people develop understand where the behavior things come from. So it's really that need to make things wrong. And looking at this whole history, the changes we expected, the experience we had, when it comes to injustice, you will see that as wrong. That one right is right.
Thank you. And the allegation that he is a bully, how did you perceive it as a person who's actually studied his personality?
So when people are out there, they can put different labels on his behavior in terms of whether it's bullying, whether it is aggressive. It also depends on how you perceive the information. So what people see and how they see it is different. They see the frustration, they see the irritation, they sometimes see the self-righteousness where he believes that he is right, although he might not be right. But that is what people see, and then they put labels on it to how they want to explain it.
But what is your own opinion as a person who studied his personality?
So, in terms of my experience of the person in my work with him, I have, as I've mentioned in my report as well, I have experience with him to be approachable and forthcoming with information. There were no restrictions on what I could ask and not ask. If there was I didn't agree, he would tell me about that, and we would discuss it, but I never experienced it like that, which is different from the protocol that people have seen. But yes, the point is still that I've mentioned if
Then these two aspects, which is his concern for the poor that is informed by his upbringing, and his aversion to injustice, how do you think they will play out in the sentencing, which is what these proceedings are about?
Your Worship, I'm not sure I understand the question.
Yes, but why are they relevant for her ladyship to take into account in sentencing?
So, if I put it all together as the two pieces that are considered, he's a voice for the people
Yes.
and he's serving the community. So, if we then look at custodial sentence, we don't only take out of the equation of family person, but we also take out the person who dedicated his family, dedicated to the service of the community, which impacts society, and that is really the link about it, fight for the poor for justice, and to make a difference in society. I think we remove that the people supporting him, there's a void in terms of the voice, and the project we the community, we all these letters of to make things better for the people, maybe in not be sustainable.
Yes, thank you very much. Now, I just also want to close this part by dealing with the criticism that 5 hours was too short. My understanding of your response is that when you are doing a personality assessment of this type, it's not just the accused, it's the accused and other people who know him. It's the research on publicly available sources. It's the compilation of the report, and then it's further engagements with the accused. Firstly, am I correct in outlining those steps as being the actual sources of the report, not only the 5 hours?
Your Worship, that is correct. It is an approach of getting information, verifying, and getting it from different sources. Sometimes when you look at sources to verify the information, so it is a combination. And I just want to add that it's not necessarily about assessing the personality of the person. It is about looking at the behavior, looking at all the circumstances of the person, and how that impacts and how you look at that in the context of the crime, what would have contributed to it, or also in terms of society, how it can impact society. A person gets released in society or go to prison, and that is where the combination of everything comes together. When the news comes to the recommendation, it's really looking at all of it, but in assessing it, it is a combination of everything if I can give an example, when I received information about the soup kitchen, someone used it before I had the opportunity to go there. I did a research to see what can I do, does these things really exist? Is there a pilot program? Did anyone ever qualify for it? And in that search, I came across to see, we also donated to the Tembisa child welfare. No one disclosed that information to me. I came across to public sources while I was validating other information that I obtained.
And so the correct way of assessing it then is to look at that period in totality.
It is to look at the person's mentality and the life up to now, and working also from the premises that we are now are influenced by what happens in our lives and the decisions we make as well.
So it's really the quality, not the quantity.
Yes.
And also just to deal with the quantity problem. I mean, when you look at everything you've done to compile your report, can you give a sense of how many hours you've actually spent? Or weeks or months?
So as Your Worship, I started off first, before I even started off with the witnesses in the case, I asked for a copy of the docket, so I was going through that with, and I started with evidence, what was the statement, and things like that. That took quite a there's a lot of information out there to get an idea and to get some of my things. So I spend a lot of time listening not only to the full proceedings but also to YouTube videos where the accused would, accuse the supporters. And I also give there some information in terms of his stance against and the warnings against drug and alcohol abuse. With some those type of information, I think this is some people told me, and which I have other information to verify. So it's difficult to keep in time on it. When I start writing the report, that's probably if I write something, I wonder about it, and then I wonder whether it is really supporting information for that. I will look for it. I will sometimes speak to someone who I will search to see whether this is supposed to say that the purpose of the collateral interviews, apart from getting additional information, is in essence to verify the information that I received from the accused and his wife usually, but also speaking to the wife who is things and they would come up with information that they got back.
Can you assess the total number? I mean, the thing that stuck with me during that part of the exchange was that 5 hours is too short.
5 hours with the, I spent about 5 hours with the kids, with all the others, with at least have been another 6 or 7 hours. That's excluding the research and the of having discussion.
And when you add all of that in totality,
If I can exclude the writing of the
no, include the writing because it's part of your assessment.
it's probably in days, probably about 12 days.
Thank you very much. Now, you also were taken to task about the distinction between what the video shows versus what he was charged with. And you seem to take the view that what's important for you is what Mr. Malema was charged with. Can you just explain that distinction?
And part of that relationship, and again, I'm coming back to the profile of the accused, there is a myriad of information there, and it's very easy to bring in things that's not part of the case or that is not been charged of or any other matters that we may be in, and then it derail, I think, the process because that with any other case, all here is to bring the personal circumstances of the accused to the court and to look at this particular matter. But because of his profile, and I think that also added to the time I spent to see what would be relevant here, what is evidence, and there may be other cases, but is it relevant to this matter, and how do we focus on this matter and not bring in additional things that may not be as relevant to the education.
Thank you for that. Now, there is also been a suggestion that these reports, in other words, reports similar to yours, are a product of a cut and paste. Now, no evidence was produced that your report is a product of a cut and paste. But nevertheless, the accusation has been made and thrown into the air. Can you respond to that?
Your worship, personally, I have a thing about cut and paste, but when you look at the report, there are also similarities that can create that impression. So if I have referenced a specific book, I may bring it into a report, I may not necessarily do a cut and paste, but that you will see certain things in which relevant from one report to the other, where I've got theory or where a specific case, it's similar cases, and you refer to a case law, you might find those. But other than that, it is every person's story is unique and uniquely presented uniquely to every person's story. And as I said, from a personal point of view and how I approach my work, and people working with me know that I have a thing against copying and pasting.
I think were to answer this particular report, is this a product of a cut and paste?
No, it's not.
Now, a lot of time was spent on the cases. Just want to do that exercise because there were 2 or 3 things that needed clarification. To start at page 40, start at page 40 of your report. There was confusion in the cross-examination about the relationship between page 40 and page 41. Can you just clarify that first?
So page 40 was really a few cases that I've indicated to say that when you look at irrespective of series of crime, there are sometimes exceptions in terms of circumstances and also the circumstances of the people involved, the accused. The page 41 is really cases that I was looking for to see whether I could find any indication from sentencing relating to discharge of firearms, reckless, the reckless behavior associated with it, to assist in the absence of having found anything specifically for the discharge of firearms in the regulatory. So it's really just a list of cases to say I have to look at these.
Now, there are 2 cases I want to reference at page 40. The first one is the third case of Akko. Remember, you debated that at length with the cross-examiner. And he expressed the view that the fine of 50,000 appeared to be rather light considering the offenses. Can you just respond to that directly?
Your Worship, when it comes to determining the crime to respond to severity, and I've also indicated at the end of my report that the sentencing still rests with the court.
Yes.
And that the court determines, based on the information I'm provided, whether it would be suitable and what would be suitably severe. It is not something that I would propose to the court. I can make suggestions as in this case, but at the end still have the responsibility. My role can never override that responsibility. So it is the court's decision.
But as I understand, you supported that sentence in that case.
At the time, yes, but in terms of the amount associated with that, I would never give it information as to what would be severe or suitably severe, to look at also the seriousness of the crime balanced with the circumstances of the person.
You supported more the principle that incarceration is improper.
Correct. Yes, Your Worship.
And the next case is the case of Bezos. I think it was the case of Mr. Alex Bezos.
That is correct, Your Worship.
And you said it was a private prosecution by AfriForum.
That is correct, Your Worship.
And the sentence there is 100,000 rands fine or 12 months imprisonment, added to a 6-month correctional supervision and a direction to perform community service. Now, is this the case that you also supported that sentence there?
A non-custodial sentence, yes. Part of the considerations there, I know there is a big concern with regards to gender-based violence, but also referring to the article of Justice Cameron, where there was very strong sentiments that certain of these things and violent crimes and the violence in prison, looking at the circumstances, sending everyone to prison, and you can often perpetuate the issue rather than make it better and resolving it. It was part of the considerations, and I have also left that to consider cases of gender-based violence and how it occurs. And specifically, also, it is a big concern, but we want to also much more exposed to what you look at trends, there's no trend of violence in the court or anything like that. So it's a number of considerations. It's not always as easy to say this is the case and this is the matter. You bring in personal circumstances. Every person is different and personal circumstances is different. And in another similar case, you might find a person who is physically violent, who has other violent tendencies, violent to other people. So there are a number of considerations that we need to apply. And my focus is always to bring the personal circumstances and try to do what happens.
Yes, I mean, the ACOP case is unique in this context because similarly to what we are dealing with, it's also about a negligent use of a firearm. It is also a discharge of a firearm.
So which matters?
ACOP, the third case.
Yes.
But the presiding officer in that case felt that a non-custodial sentence is appropriate.
That is
And similarly, in the Bezos matter, it is a GBV issue, which is a big public concern. But the presiding officer in that case also felt that a non-custodial sentence would be appropriate.
that is clear.
Now, you've explained what page 41 is doing, but I also want to do the same exercise in relation to that. So you clarified what that is doing there. It's similar cases or cases that.
We similar charges were raised, you will show.
Yes. What do you mean by that?
So if I look at the first one, although it was murder, it was also charged for reckless engagement in personal property, for which the case was sentenced to 2 years imprisonment. It's not similar to this case, but it is a similar charge for another incident. And in that instance, the person was sentenced to 2 years imprisonment.
And then perhaps the second and the third case, which I thought were probably the more on point here.
Yes, so I think it's similar in the way that it would be discharge of a firearm in situations that could have injured people. The difference of it is that the standard indication that those firearms were distributed.
In relation to which case? The S versus Pistorius case.
It was a mysterious one, yes, and the one that was referenced in that other mention in the other hand that was referred to.
And that's which one, the third one?
Yeah, the third one.
Maybe your worship, this case will be given to you in due course. The case of South African Human Rights Commission and another versus Malema and another. If there's a copy, yeah. I beg leave to hand this up. Perhaps the witness also doesn't have one. I should give. I will use the. Oh, yes. One minute. I think everyone has it. I would like you to just read paragraph 16 into the record of that judgment.
Pursuant to this incident, the second complaint was arraigned in the Kyle Magistrates Court on charge of assault of Mr. Okama, and Mr. White was also charged with the assault and with the possession of firearm in public place, to which he pleaded guilty and trial, the complainant was found not guilty on 10 November 2026.
Is that what you are referring to in your third column?
That is correct.
Now, if we could then go to the yes, I'll go to the other cases that are in this article. But before we do that, I just wanted to address this allegation that this whole point about a fine is tantamount to paying your way out of prison. That is the phrase that was used. I mean, the first difficulty, which perhaps you can address, is that a fine is part of the sentencing architecture of this country. It's in the legislation.
That is correct, Your Worship. I have also indicated when I looked at the Firearms Control Act, these offences were all violations of certain sections of the Firearms Control Act that the Act provides for either a fine or imprisonment or both.
But there is a second issue that I would like you to comment to respond to this phrase, paying your way out of prison, which is what impact does that actually have on particular biases against people that are perceived to occupy a certain level of status in society? Is it the case now that merely because you charge a politician, a fine is inapplicable to them because they can afford to pay?
Your Worship, in responding to that last question, I think that is what I was bringing across.
Yes.
That irrespective of the status, it is still a sentence. And yes, that is the need of the considered
Would you say that Mr. Malema's standing as a member of parliament should be irrelevant to the question whether a fine is appropriate or not?
I do believe it should be relevant. The consideration is still the impact that a custodial sentence would have depending on the nature of it. But it shouldn't be a consideration because it should be based on the impact that it would have on the community, society, and the citizens.
There is also another aspect related to this, which is people like Mr. Malema can afford to buy your services. You remember that. Now, could you just deal with that? Because it's left hanging, because there is a sense in which you are told people are buying your services, but when you want to disclose how much are they paying, you are told not to disclose it. And so the impression is created that you are a social worker for hire. But just deal with that, because it may leave a really bad impression.
Your Worship, like any person, professional person who renders a service in their private capacity, you are paid for your service, and that is contracted or indicated to your extent of transaction cost, and that is what you pay for. When I had the initial discussions and the request to receive from the court, I also set the boundaries and the rules for the way I render the services. And that is that at the end of my report is done, I'm happy to give the factual information to read that those type of things. But when it comes to my opinion, it is not negotiable because I need to stand here in front of the court and speak from the conviction that this is my true belief, and I have taken the oath to say I will speak the truth and whole truth, but nothing but the truth. And in that, accept that other people are different from you. But it is not a service from higher for hire. And if I understand correctly, when you can come to me to say, we have this case and we want this type of sentence, and you please do the report. Doesn't work like that.
Yes. You see, the other reason I found that line strange is because the fact that your services were requested was in fact raised by her ladyship herself after the conviction, where an offer was made to Mr. Malema that the court could arrange a professional of your services to provide exactly the same service. And now it's turned around and you are being criticized and Mr. Malema is being criticized. So I asked my learned leader to show me where this part was dealt with. It's on the 1st of October 2025, after the conviction judgment has been read, at page 38 of the transcript of that day, where Her Worship says, Advocate Hodes, may I just inquire on this pre-sentence aspect? Will you be following the normal route that is followed, or will you be using your own? Then he responds, our own, Your Worship, in private practice. And then the judge says, okay. Then Mr. Hodes says, the signal is bad, Your Worship, but I've attempted to get hold of Mr. Ina Thompson. So they've known about this long ago, who does reports regularly and is qualified with an LLB and a degree in social work. She does a lot of these reports. Then the judge says, the reason why I'm asking is merely so that the clerk of the court may know whether she should prepare a request for the normal route, but now that has been ruled out and the defense will do so on its own. So this is not a special favor to Mr. Malema. This is a normal route.
Yes, Your Worship, when I suppose conferences to check my availability, and I indicated that I'm available on that day. The only later told me that it was
In your line of work, do you also do reports for victims of crime as opposed to perpetrators?
I've never received a request, but where there is a victim, it's not society that's where impacted, but there is a victim. I always reach out to the prosecutor in case if there is another victim impacted for a statement from the Department of Social Development. I always reach out to the prosecutor to ask whether they would be comfortable if I also include the impact on the victim within my report to give all the information about the victim.
So you try to incorporate it into your report.
If I do, if there is no independent statement, because it is an important part of the proceedings and it is important that the police reports are good. And if I am then permitted to do so,
Yes, because in this current report, and that's something that came towards the end of your evidence, there is no reference to victims. Is there a reason for that?
it is because there were no individuals that were harmed. So in certain sense, one can probably use society as a victim because of the perceptions that it would have created, but there was no indirect reasons that were impacted or harmed to that came to the court.
Now, just on this issue of money, remember that you wanted to disclose your rate and then you were told not to disclose your rate. Do you actually want to disclose your rate or not? Feel free to, because the impression is that there's a lot of money being paid to you, etc.
So in this case, I have not concluded the case yet because it is, the time-wise, it is much more than my average rate. But in average, my normal cases, in the normal way of the running case, sort of more or less the same time. I do cap it, and I also tell the accused I cap it at 15,000 rand. That's an all-inclusive rate for considering all the research, the interviews, the reports, the appearance in the court, because I need to make it all although it is a business and I need to be paid for my services, I also need to make it as accessible as possible. And then where there are requests for very specific circumstances who cannot afford it, I have done it several times.
Don't worry, Ms. Thompson. If one were to ask the attorneys in this room to produce their rates, there will be a lot of embarrassment. Your rate is very, very low. Thank you. I want to then come back to the cases in this document. I think there were three that were, or two that were specifically referenced. You still have this article called A Note on Sentencing Practices for the Offense of Unlawful Possession of Semi-Automatic Firearms by P.T. Toy. So go to page 11. The first case that was referred to and the way it was presented is that it is on point, not just similar, but on point. As versus similar, as versus Asman, it's a judgment of the Supreme Court of Appeal. And I remember you constantly asking, what are the facts? The facts are set out in the judgment itself at paragraph 1. And I just want to read this out for you. It's a judgment by Judge Shongo. On 2 October 2008, the appellant, Mr. Yusuf Mohammed Asman, was convicted by the KwaZulu-Natal Division of the High Court on charges of kidnapping, murder, and the unlawful possession of a fully automatic rifle, to which an AK-47, read with Section 51 of the Criminal Law Amendment Act. He was sentenced to 8 years imprisonment of the kidnapping charge, life imprisonment on the murder charge, and 15 years imprisonment on the unlawful possession of the firearm. And we know the firearm to have been an AK-47. The court ordered the sentences to run concurrently with the sentence imposed on the murder charge, i.e. life imprisonment. Now, just having listened to the summary given by the judges themselves, does that case bear any similarity to what we are dealing with today?
Your Worship, apart from some of the charge that is in there, I do not see it. When I would have had to look at it, there are certain things that indicate the pattern. You work with only one charge, there are other things linked there. It speaks to the reasons why the court brought this into the minimum sentence of the state minimum sentence of June. So it is different and it can't look at it in the
Well, there's murder and kidnapping, so the possession is in that context.
And even if the other firearm for which the appeal was upheld was not linked to those, there is still a concern pattern where firearms are used for violent crime.
Which is the point you've been trying to drive today.
Yes, Your Worship.
Thank you. And then there is another case. I think this one is Swartz at page 15, which also was cited as being similar to this case. Now, when you look at the Swartz case, if you look at page 15, the second paragraph, are you there? Of the article. Now, there you will see that there is no actual summary of the underlying facts in the article itself, which makes us to then go and find the judgment itself to see what actually was going on. Now, in paragraph 3, it's an appeal, a judgment of Judge Rogers when he was still in the High Court before his elevation to the Constitutional Court. It says, the facts and respects of counts 1 and 2 are that on the evening of the 28th April 2012, Arendse was patrolling in Pumlani in the Lotus Refuge area together with a member of the neighborhood watch. They came across the appellant, who was in the company of another man. As Arendse got out of the patrol vehicle to question them, he saw the appellant take something from his pocket and throw it over the nearby fence. Arendse searched the appellant and the other man, but found nothing on them. While the member of the neighborhood watch guarded the appellant, Arendse inspected behind the fence and found a cocked semi-automatic pistol with 8 rounds of ammunition. The appellant's version, which the magistrates rejected, was that he had been in the company of 4 other people, that he had not been in possession of the firearm or thrown anything over the fence, and that he had not seen anyone else do it. So again, just that basic summary. People being apprehended and then throwing an object to hide it. And then that object is later found to be a semi-automatic rifle. They're asked about it, they denied. And those are the facts. Can you comment on the similarity between that case that was read out to you and what we are dealing with today?
It is, again, it speaks to the position and what would be the similarity. But in terms of the detail of the matter, and some of the information is obviously not being used because it's speaking to people and going to be telling you the case goes to the family. But what would they want? Why did they have, even if they knew the story, why did they have to listen? What was the intent of them? For how long did they have it? There's a lot of questions that I don't know, but it doesn't face value in some of the things.
Now, in this particular case, as I understand, those were the only 2 cases that were extrapolated from this article. Now, in this particular case that you were dealing with, you mentioned earlier in your cross-examination about the absence of a witness who was either harmed or scared, because there was a suggestion in the cross-examination that people could have been scared. And I couldn't work out whether there was any evidence that there were people that were scared. People could have been caught.
I haven't seen any evidence when I was with the information to my availability that indicates indicated that there were people that were scared and probably running away with them.
And then there was also this question around the one case you cited, where someone is not shooting at a particular target, but is shooting in the sky. And the purpose of the shooting is to celebrate. Now, I mean, have you found, you've done thorough research on this, any case anywhere closely approximating what we are dealing with here?
You wish if I hadn't found anything, and that is when I was started to look, when I started to look for other cases where I might find similar charges, because I couldn't find anything specifically relating to the discharge of a firearm or celebrating purposes.
Thank you. I'm going to leave the topic on the analysis of the cases that were put to you to another topic, which is this role of remorse. I just want to understand what your evidence is. Your report says that the accused regrets the consequences and the attention that was paid to the incident, regrets the incident. And he also regrets the fact that people might think that the use of firearms is acceptable, following his example. And then you said, well, remorse does not aggravate. How do you see the role of the position of the accused specifically? Yes, the relevant parts is is page 19, paragraph 46 and 47. If you want to remind yourself.
So, as I mentioned, I don't see remorse as the aggravating, the absence of remorse as an aggravating factor, but the existence of remorse is a mitigating factor. In this instance, the accused claims that he is innocent, so I wouldn't say that there is remorse in the true sense of the word, but if one links it to say is rehabilitation needed, do we need to convince him to be a better person? The fact that he understands the seriousness of what could have happened, even though it's not part of his own, perhaps not understanding like that, and the fact that he regrets that he created the perception, which was not, he wouldn't have wanted to create, that it is acceptable to be reduced to firearms indicate that a way of thinking that would prevent you from doing a similar thing again without having to go or consider rehabilitation to convince you that this is totally wrong and it's dangerous.
Yes. Now, you were criticized that the sentence you are recommending is just too light. I think that's really, if we had to strip all of this thing off the verbiage, to say this is just too light. Okay? There is a range. There's custodial, there's suspended, there's a fine. That's a range. I just want you to explain to His Ladyship why a non-custodial sentence is in fact the appropriate sentence in this case.
If I just ask you, we have on the case the fact that it was a celebratory shooting, the intent was not to harm anyone else, that even the position was for a short period of time, there was no intent to keep it for so long period. Together with that, if I look at that and I look at society and I say we are removing a person from society, and that is contributing positive to society, that is a family person, and removing people from the family is also have a role in society. If I look at that and I look at the price society is paying for a social sentence, the question that I have is, that's what we gain from it is send a message to people who is incorrect, and I know there's also views on the term value of it. Does it really justify the price that is being done to pay for the people on the community
Thank you. I have nothing further with it. I just want to see if my colleagues feel strongly about anything else. Thank you.
Worship, the only request would be that the report be accepted and marked as an exhibit. That's the only request at this stage. Thank you. Clarification. Thank you, Worship.
To me, I'm not going to nitpick, but it's the only opportunity I have to ask you to avoid having to ask you to come back. So just bear with me, please. If I am taking from memory now, you had informed the court you had spent time as a social worker and also amongst correctional services. Therefore, I may assume you are familiar with, as counsel read out, the procedure the court had offered and wanted to distinguish whether the defense will follow the social worker or the probation officer's report and or correctional services report. You are familiar with those reports. In effect, it is exactly the same as what you are doing. It's just the one is the government and this you are private. That's the only difference. Okay. So I don't have an issue with that at all. I also want to inform you that in this instance, as correctly said to you, by you, the court is not dealing with substantial or compelling circumstances. It was not invoked by the state because that is now minimum sentence act. And here the state is going on the principle of 15 years imprisonment in respect of count one is the maximum term of imprisonment going down. So that's why I'm not going to discuss compelling and substantial circumstances. It's an academic point. With your experience and what you've drafted in this report, in short, what makes any of the facts contained here different compared to the lives of a million other reports with exactly the same contents?
Your Worship, I think the risk is the same to the injury of people, but the reasons in terms of why the firearm was obtained, if I look at the Firearms Control Act, where in terms of the spirit of the act, it was to get firearms off the street that is used.
Okay, no, look, I don't think, maybe I have not been clear. Let me be. What in this report that the accused comes from a humble setting, worked his way through, is now a provider. It is not different to every other person appearing in a court of law daily.
Your Worship, is
That is what I'm
the
asking.
personal circumstances of a person
Yes,
is it's unique to every person, but
yes.
it is presented to the court in all matters.
We all agree on the fact that it's unique to a person, but what is unique in this report?
For me, Your Worship, it is more on the substance of it in terms of the contribution made to the community and
Okay, let me just ask you the contribution you say made to the community, okay? Let us just stop on that point so that we don't lose track of the long sentences. Okay. My question on that one would be, so are you saying to this court that if you contribute to the community, it's fine, you may commit an offense?
no, Your Worship, not at all.
I
It's
see.
part of the considerations.
Part of the
And
consideration.
it speaks also to the aspect as to what are the risks of committing crime again.
Okay, then while we're on this point, you've emphasized throughout your evidence at a direct question by counsel, why is it appropriate that a non-custodial sentence be imposed? And you replied by saying, because it was a celebratory shooting. That was your reply. Okay, so that was your reply. I'm saying to you that was your reply. Now the question is as follows. Because of the nature of the shooting, anyone who's having a birthday today may walk down Oxford Street, shoot a firearm, and it's their birthday and celebrate. Is that what you are saying?
Not at all, Your Worship.
Just explain the difference in people.
Your Worship, so what I mean is that it was used for a celebratory shoot and obtained for a
Person
celebratory
outside will be
shooting.
using it for that same
When I
purpose.
compared it to the other cases, it wasn't obtained with the intent to keep it for a long period, to go and commit other crimes, and to contribute to the violence in the country and the firearms that need to be.
Let us just stop there because you've answered and your answers are very long. So that brings me to the next portion of this report or your evidence, which I wanted to ask you about, which you mentioned now. It seems as if you are, and please correct me if I have this wrong. It seems as if you are contributing or attributing the shooting or the firing of a firearm that it must be accompanied with violence. Because you are referring to there was no violence. There was no violence.
Your worship, that is a consideration, and if there were, if you look at it all together, if there were injuries, it would then
Yes.
aggravate the
Yes.
circumstances, and it would be aggravated circumstances that would inform a more serious sanction.
You see, that is maybe why I have a difficulty to follow you here, because you are saying it was a brief period of time, it was a celebratory shooting, and there was no violence. And you could also not find a similar case of this nature. Now, so what?
A similar case of that nature, your worship, is really to indicate in a situation like that what would have the sentence
Now
been.
we know there is not. So does it take away any of the charges? Because this
No,
is
it
the
does
first.
not at all, your worship.
So I don't understand this.
It does not take away the contents and the charges. It's
Because
still
I'm concerned that you are also telling this court that your client is very concerned that he has created the perception that one may be reckless with firearms and that he regrets.
That's correct,
So
your worship.
we are all on the same page. And as you have explained in length, that yes, every person may plead guilty. That is, are not guilty. That is a given. And remorse is not a requirement. So we are on the same page there. But you say he regrets the perception. But in the same instance, it's fine because it was a celebratory shooting. So what is it that is being said here? What is the perception that we must take from this?
So, your worship, it was a celebratory incident, but the expected outcome is that it created the wrong impression, which is regrettable and was not the intent.
The impression is that this was a planned shooting or firing at the birthday event. So what impression is it that was supposed to be perceived? What is it being? What is the perception?
So, your worship, linked to the other charges, it still remains that those things were not considered, and then it created the impression because the necessary caution was not applied, leading to the charges of the endangering and the recklessness.
Okay, let me leave that. I've only two aspects left. No, a few in fact, because if I had it in before the time, it may have been a different story. The other issue, not an issue, but if you can explain, I think if we go in the circle of a radius of 5 kilometers on each side of the court building, we're going to find about 4, 5, 6 soup kitchens. So, and this soup kitchen is specifically to the area Mr. Malema is coming from.
Correct, Your Worship.
So that is, what value must the court attach to that? Because I've read it's from donations.
Part of, yes, and through the participation or the involvement of the accused, Your Worship.
So it will continue.
It will continue, most likely, yes.
So there's nothing special about the soup kitchen,
There
except that one may be very thankful that people are being served a meal. That is outstanding.
Yes, Your Worship, and it was mentioned as part of the considerations in terms of the risk of reoccurrence.
You also said the accused has a desire to right a wrong that is driven, that he must right a wrong. Did I understand you correctly?
Your Worship, it explains where behavior is coming from. It's that if I perceive something to be wrong, naturally some people would be inclined to try and correct it, others would not.
Please, if you
depending
can.
on the personality profile of the
Okay.
person.
Did I summarize what you said correctly? That the accused has a desire to set a wrong right.
To set right, wrong, yes.
Yes.
Wrong, right, yes.
Yes. So in this case now, who gets to decide what is right and what is wrong?
So Your Worship, what I meant, and that's why I said also perceived wrong. So if the accused looks at something and he sees it as wrong, his natural response would be to try and correct it.
So if there's an act that says you may not do it,
Yes.
then it's okay. If he decides you may because it's celebratory, then it's fine.
No, Your Worship. That is not what the intention of that is.
No, not the act. I'm going on what your
No,
evidence is saying.
In terms of explaining behavior, so that is usually what we drive in when we take action.
Okay. Now the very last sentence you said, second last one. You were asked by counsel now specifically the fact that Mr. Malema is leader of a political party is irrelevant, and you said it is irrelevant during sentence. Did I hear you correctly?
My understanding of the question was whether it is relevant to the matter as to whether it should be a fine or not, whether it should determine the sentence. And my response was no. So my understanding is when it comes to the status of the person, that shouldn't in its own determine the sentence. It should be based on the facts of the case and the personal circumstances that it would consider.
And therefore you do not see that based on that, there is a responsibility and an accountability factor because of the very reason you are now saying it's relevant.
I'm not sure I understand.
Okay, let me try again. Sorry. You are saying, I've lost most sentences. Where did we stop?
So, Your Worship, so maybe just listening to what you were asking, if I'm understanding it correctly, when it comes to sentencing, the fact that it's a parliamentary member, the status should not.
You said it's irrelevant. Now, that's where we go. Thank you so much.
The fact that he is a parliamentary member also means that, as I've stated in the report, that people may emulate his behavior. He has a responsibility.
That's what I was asking. So I couldn't reconcile it being not relevant to it being relevant.
The relevance was more linked to the status, that the status of the person shouldn't determine that. But the work relating to the parliamentary role, it comes with the responsibility. We really have to act more responsibly because people can.
Last question then. You answered the question by counsel as follows. You said we need to ask ourselves, is it worth the price that we are going to pay as a community? Can you explain that statement to the court?
So Your Worship, when we look at custodial sentences, particularly, it has an impact on the family and it has an impact on the community. And with the family being the cornerstone of the community, and one cannot always predict what that is. So if it impacts the community, it also impacts the structures that it could eventually perpetuate situations rather than to prevent it.
In essence, can you explain to me what you mean? Is it worth the price we are going to pay? Is it worth it? That is what I'm asking you to explain.
So the price could be the impact on the community, having an impact on the family, having a ripple effect on the community, and also risking and Your Worship to clarify that the sustainability of the community projects is investing in the community and
So do you mean then that is a pardon?
it is not a pardon, it is just with the impact there, if one considered that, would that still justify a period of imprisonment or not?
Thank you. Advocate Caesar, any questions based on the court's questions?
Sorry, Your Worship.
Sorry? Do you have questions?
No, Your Worship.
Oh,
I
then
think Madam, you're asked in relation to the distinction to be made between this case and other cases, and you were taken around why this is so different to all the others. Any other instances that you refer to related to other violence that accompanied it? You said that you couldn't find any case during a celebratory shooting. My question to you, rising from the worship's question, is: in any of the other cases, did you find any instance where there was no intended target when the shooting took place?
I'm not 100% sure, Your Worship. There might have been, but there were also cases where it was, sorry, Your Worship, there were the matter that we referred to of the shooting in the case that council went through. The person did fire a discharge, just a firearm, but there was no intended.
Which case is that, sir?
The one in the South African Human Rights Commission in one, that
And
paragraph.
then there was
that
a conflict situation.
It was a conflict situation.
So
but
there
it
was a violent conflict situation. There were prospective or intended targets, and in this instance, is there any intended target?
There was not an intended target, no, Your Worship.
Now, you asked a question by the worship relating to the suit kitchen, the Masakaning suit kitchen. What role does this accused play in relation to that suit kitchen?
It started off as his initiative. He, when they do struggle, he would engage to ensure that there are sponsors from the community, so he would facilitate the process and to ensure that it's run properly and that the people have the means to run the
It started as his initiative, and once it was implemented, it became further.
when his help is needed with something, if there are issues with sponsors, so he can intervene, but he's not actively involved in it.
Now, I'm going to ask you the question that everyone seems to be skirting around. In your view, what role does the status as a member of Parliament play in the sentencing proceedings? Has everybody asked you whether it has an impact, has no impact? What role does it play?
As a member of Parliament, we would want him to be seen as acting responsible, and within the suiting, that was not the case. So because of his role as a parliamentary member, people might emulate the behaviour, and from that perspective, one needs to consider the seriousness.
But what impact does it have on the proposed sentence that ought to be imposed?
It is really part of the considerations of the seriousness as per my report.
I'm not very good.
thank you, Ms. Thompson. We have finalized your evidence. You are excused and you may stand.
Richard, that is the evidence in mitigation of sentence, and I've now the evidence to read the officer to the court to accept it as the next exhibit.
I'm going to move.
Exhibit here.
So Sorry, before I mark them all, you're not formally submitting the article of Toy, not so. Just the state now. It's only the report that I'm going to formally admit at this stage. That it was handed. Okay, let me hand it to you. Okay, so is it? I'm thinking since we are busy with sentence and we've had so many exhibits that we mark this one in the form of sentence. So S for sentence, S1, S sentence 1. Okay, everybody available tomorrow? I am. We're not going to get to do all of this again. Night court?
Which is what I had in mind. The state has informed me about this case. I'm still waiting to see what it does.
Yes.
So I'm waiting to get that still. Should the state close its case at this stage, my proposal is to
Please, I
compile,
can't hear. Please.
to compile written letters of argument by particular date, or range of dates for hearing and sentence on the very same as if there are any issues arising from the written letter can be dealt with on that point and sentence can be imposed thereafter.
Is that what the parties have
No,
discussed?
I haven't discussed it, what I think. We thought that we finished earlier and it was the argument related to that, that just didn't happen, so this is right, and I'm glad to accept that. And I just make that clear on fault, it's asking for dates, and I don't like to worship, so I really talking more focus over there. That you should come see your worship just to raise it, right? It's asking for a date next week, your worship, I don't know, I could possibly come back, I have a matter that's in Bloemfontein on Monday, but I don't believe it's going to run because there's a judgment handed down today that impacts on that matter. So I figure tolerate something.
If you're saying next week, will that be for you to file the heads
I
or
don't know
to?
what everyone is
before?
saying, but I see next week, every week's next week.
I can file my exam this week.
Yes, when will I be getting the heads?
Yes.
I don't want them on that day for the first time. Oh, I can try, but
Perhaps we should take a week to do the heads and the following week. And I could possibly tolerate something in the 3rd and the 6th of February. I don't know if we should try them already, but
I think it's just something we all need to compromise and play
I
along.
cannot do the 2nd.
Mhm.
I could make an arrangement for the 3rd.
Look, I will avail myself because it's something that we must. If you want to word with your client, yes, to establish everyone's schedule. But from my side, unless I'm not present, I will try by all means to incorporate it into that day. The year's booked, but I can pre-arrange and deal with certain matters.
I have a similar situation.
Yes. Okay. Then I'll do that. All right. No, you're going to discuss dates first, and then I'll come back to court. Is that what you're saying?
Not only me.
No, he wants to take instructions from the others advocates, Caesar, or obtain or hear from their availability and schedule. Is that what you? That's what you're saying.
I'd rather set down the entire term starting from Monday, but I don't anticipate once that it is provided to see it.
Okay. What time do I come back? 10 minutes? Stay 10 minutes sufficient? to adjourn for the moment.